So good morning, good afternoon. Thanks so much to those of you joining today, both as panelists and guests tuning in for this virtual symposium focusing on restorative justice in legal education, hosted by the National Center on Restorative Justice. As you have seen, the aim of this symposium gathering is to explore the applicability of restorative justice content and practices in the law school context, and what restorative approaches have to offer within the field of legal education more broadly. Throughout the symposium today, we'll be hearing two different panels and speakers that is a mix of current law students and recent graduates, as well as some time to hear from one another and meet each other through a breakout session. And then we'll close with a career panel at the end of the day to hear from a couple different folks who are doing different kinds of practice, those who have a JD and are in a kind of a variety of practice related to restorative justice, to kind of paint a fuller spectrum of what people are doing with those two interests and areas of background. So before getting started with the symposium, I just wanted to do a couple quick introductions, both for myself and our National Center team more broadly, and give a little bit of quick context as to how and why we decided to focus on this topic for the event in particular. So my name is Alana Ojibwe. I use she, her pronouns. I'm the Assistant Director of Education and Outreach with our National Center on Restorative Justice team. And most of the work that I do is related to creating a wide range of free and publicly accessible education resources and materials for people to better understand restorative justice and the impact of restorative practices that can be used in a variety of different settings. In addition to that, another area of my work is really serving as a bridge to create new networks and collaborations for those working within higher education and interested in restorative justice. The National Center on Restorative Justice is a partnership between Vermont Law and Graduate School, the University of San Diego, University of Vermont, and U.S. Office of Justice Programs, specifically our funding partners, the Bureau of Justice Assistance. We are charged with addressing some of the pressing needs in the criminal justice system and are committed to improving policy and practice through restorative justice research, public education, and higher education. So as you can see here, this is sort of a snapshot into what those three primary areas of our work look like. We tend to call them our three pillars of work in research and public education and higher education. So on this next slide, you can see a snapshot into what some of those particular initiatives look like within each of those areas. So for example, in public education, some of the areas of focus we're working on involve professional coaching and mentoring, training and technical assistance, webinars and events, videos and podcasts. Through our research pillar, we're working on research training opportunities, research communication strategies, funding support, and have a community-based research network. And then within higher education, which is sort of under the umbrella of what we're here for today, some of the other initiatives we're involved with are scholarships for certificate in restorative justice programs, restorative justice education materials library. So we're working on a resource bank for those working in education and just looking for other materials and resources to incorporate in curriculum. Wider curriculum development, and again, sort of networking for those working in education of what kind of curriculum development has been useful and can be used in different ways and in different settings. And then restorative justice education gatherings, which is really upcoming in this next year as a time to bring folks together who are already working on restorative justice in higher education. So that's kind of an overview snapshot of the National Center at large. And I just wanted to give a really brief overview into how and why we sort of landed on this symposium topic in particular. So under the higher education umbrella of our work, one of these projects, one of the networks that we've been working with is a group of law faculty throughout the country who are interested in already teaching restorative justice to some extent. Some have entire classes that are able to focus on it. Others have particular parts of a course that they're incorporating. Some have clinics. So it's a network of those already teaching and doing some kind of restorative practices in their law school setting. And through that group, there was sort of an expressed desire and need to have some kind of virtual gathering to focus on kind of these two primary areas, which is both looking at restorative justice content within curriculum in law schools, as well as restorative practices more broadly in the relationship with law school culture. And I would say throughout those conversations, there was a lot of different ideas about the best ways to do that, and diverging ideas. But the one sort of central point of that everyone unanimously agreed on is that for both of those two goals, the best way to see change really come from that, and lasting change really come from that, is through the support and buy-in from students, first and foremost, as drivers of change. And so that was really sort of what influenced the inception for this idea, which has shifted. And so the primary goal is to give a time and space to center the voices of students, both current students and recent graduate students, to talk about these two major sort of two topics of restorative justice, looking in content within JD curriculum and also in law school cultures. So we're really excited to be having this conversation, and really do see this symposium really as that, as a time to center these voices and have a conversation. So we'll be having, again, these two different panel discussions. We'll have time for breaks in between. We'll have time for questions after each of the panelists speak, and then we'll have a time for breakout sessions, and we hope that that is a time that you're really able to hear from each other and learn from each other and network. So just to give a brief snapshot of what the kind of overall day will look like, and then we'll come back, as I mentioned earlier, for a convening and sort of closing out with a career panel discussion. So that is our snapshot for the day, and I'm going to pass it over to our moderator for the day, Leah Wilborn-Nice, who's been working with us the last few months in planning this, and we're so appreciative for everything you've done and has been kind of the primary point of contact leading up to this. Leah is a practicing attorney and soon to be public defender in Western Washington State. She received her undergraduate degree in social work from the University of Iowa, and master's in social work from Eastern Washington University, as well as her law degree from Gonzaga University. Thank you, Leah, and I'll pass it over to you.
Thank you, Alana. I'm really happy to be here this morning with all of you, really excited about the panels that you all are going to get to participate in today. Like Alana said, my name is Leah. I'll be your MC for the day today. And so if we can go back to the slideshow, I'll go ahead and kick off our first panel. And just to get everybody sort of warmed up, if you could share in the chat where you're tuning in from, and then any school affiliation you have, and a word describing the place you're tuning in from, what you love about that place. So go ahead and share that in the chat as you feel comfortable. So our first panel this afternoon is focused on how restorative justice can be integrated into JD curriculum. We have 4 really incredible panelists who are going to share presentations with us this morning. We have Anna Puente Flores, Grace Woodward, Jordan Stark, and Jennifer Grubman. This is going to be a virtual circle format, and we will have a Q&A section at the end of this panel. So as we get closer to the end of the presentations, feel free to send questions that you have in the chat, and we'll ask those of the panelists as we have time. So I am going to pass the mic to Anna, who's going to kick off our panel this morning.
Hi, thank you, Leah. Thank you, Alana, and hi, everyone. Thank you so much for being here with us. I'm really happy to be here today to talk about restorative justice, and my contribution today has to do with rooting restorative justice in ancestral praxis. So first, I'm going to tell you a little bit about myself. My name is Ana Puente Flores. I come from Tenochtitlan, also known as Mexico City. I grew up in a family who identified as Mexicans, or Chilangos, as we say in Mexico City. But now that I'm in my own path and coming into my purpose, I'm a mother, I'm an herbalist, and I'm also a law student now. I no longer identify with the nation state that I was born in. The traditions of corn, weaving, and plants, which come from the land, are soothing a deep colonial wound in my lineage. And because my lineage, which originated from the Ñañú peoples of the Valley of Mezquital, came by way of a very violent law called the Law of Pernada, which meant that any feudal lord had power over the bodies of women living, working, or enslaved on the land that he owned. One of those women is the origin of my paternal lineage, and her name is Mama Tonchita. And I make this reflection because I think that it's key to have insight into our own lineages and how they connect to why we want to do this work of restorative justice. So when I married my husband, I was adopted by the Muisca of the Bogota Sabana, the community in a town called Facatativá. And I have also had the immense honor of working with elders such as Chief Justice Robert Yazzie from the Navajo Nation and Justice Cheryl Fairbanks from the Tlingit and Tsimshian peoples. Chief Michael Hecrow and my elders, Ricardo Arias and Alexandra Diaz Casas, are also guides in this knowing and becoming more aligned with what I believe justice to be. So when we refer to restorative justice, what do we mean? And I think when I ask myself that question, I think of tending or stewarding relationships back into harmony. Justice as a concept is very broad, but in some it can be as achieving a desired outcome after a conflict. Today, Indigenous peoples around the globe have taken on positions of leadership, and the voices of Indigenous leaders have been silenced as they have been upheld. And what I mean by this is that the rise of visibility of Indigenous people's voices have also come with a response of state violence and so on. And I think for this reason, this trend also makes it easy to lump all Indigenous peoples into one group, into one picture. But I think that looking at each of the complexities of each tribe, each peoples, can have some insight. So another thing that I want to talk about is an example of this kind of the reason why I want to talk about rooting in ancestral practice is because restorative justice can have a notion that it's a novel idea, but really what that reflects is a lack of analysis about the history of the way in which Indigenous peoples have been resolving conflict since before colonization. So an example of this is sort of the permaculture paradigm, and it's that if you look at the word permaculture on Google, it's an approach to land management and settlement design that adopts arrangements observed in flourishing natural ecosystems. This means that humans examine the ecosystem, and instead of imposing a way of growing food, they follow patterns, soil, and conditions in the land and work with them, not against them or imposing on them. This is something that indigenous peoples have been doing since the beginning of our civilizations. And I say civilizations intentionally because a lot of times indigenous peoples and the knowledges that come from indigenous peoples are sort of seen as non-civilizations, but these civilizations are ancient. So I think that this also could be a way to juxtapose it with the justice system, because in the justice system, restorative justice is not new. It's a practice that, as again, I come back to this point, has been going on for millennia. So now a little bit about the current justice system, which could not be further away from restoring any kind of balance. Through the justice system, families are separated, communities are made marginal, poverty is criminalized, and people are disinvested in. The land is appropriated, privatized, and exploited, and the list goes on. So what about ancestral practice? So as restorative justice practitioners, we seek to do something different. We need to think beyond the confined rules and procedures and look at the ancestral origins of restoration and justice. Everything in this life is a process from beginning to end. Our human life has phases, and each phase teaches us something. It's a kind of rite of passage to prepare us for the next part of our life. But humanity has become separate from our inherent initiations through the settler capitalist anthropocentric system. But we cannot ignore this intuitive knowledge, because when I think of ancestral, I think of indigenous peoples from all corners. So your ancestors are indigenous from somewhere too, and they too had a culture deeply rooted in the earth's cycles. And this is a key point that I want to hone in, because a lot of times through the system of blood quantum and what the settler colonial government wanted to impose on indigenous people and also on enslaved peoples was this notion of quantifying how many indigenous people there was, and then how many Black people there were. And through this, the system of racial capitalism was built, And so this notion of indigeneity, I think it's a broad question, something that I will not be able to go into depth a lot because of time. But just one reflection that I want to offer is that that our ancestral lineages have those knowledges through each one of our cultures. So again, going back to this idea of our ancestors are indigenous from somewhere. If we do that analysis of where we come from, if we do that analysis of what values, what systems of governance our indigenous ancestors had, and then also analyze the fact that we also have, in my case, settler blood. I'm mixed blood, so I also have that blood in me, and those systems are also ingrained in me. But what can I do to make that analysis and a conscious change as to what core values are going to guide my principles of justice, my principles of restoring relationships? And it's very hard, and it doesn't always come about institutions. So the many way indigenous peoples do peacemaking processes is following certain cycles, and these cycles are always mirroring a process of the earth or universe. Some call it universal law, and these translations can be hard because a lot of times these translations are embedded in codexes. For example, for my Mexica ancestors, they're in codex, they're in pictures, and we don't have a translation to English. For the Navajo or Dene people, they have a system of governance, and their language has meanings ingrained that give meaning to life, which go way deeper than what English could explain. So that's just one example. But often these values and systems of justice and governance are passed through oral history. So for example, the Chief Justice Robert Yazzie calls the Four Directions method a way to practice this traditional law of restoring conflict. The Four Directions method, which follows the cardinal directions, with each direction comes a teaching about the animal that guards that direction. Each animal has its own personality and story to tell, to make people involved in the peacemaking process reflect on their attitudes and behaviors. So again, that's rooting back to our positionality in Earth, to the universe, using the four cardinal directions to guide a process of restorative justice or restoring balance, but it's more called traditional peacemaking, or Navajo peacemaking, more specifically. On the other hand, the Muisca people from that have the original inhabitants of the savannah of Bogota walk alongside a very common plant in this continent, a plant relative for most indigenous peoples in this continent, which is the tobacco plant. So every process is led by the tiva, which roughly translates to wise person. And this process led by the tiva first consults with the tobacco about what is to be done, or the diagnosis to a person's problems or a problem between two people. This praxis is called mambeo, which is a word circle. And so through this consultation with a plant, there is the plant delivers the message of what is to be done. In this way, we achieve better results because humans are imperfect and we make mistakes, but plants are in harmony with natural law. And that is why we listen to them when we have a conflict or an issue to resolve. Justice Cheryl Fairbanks talks about core values, and I have noticed all elders always come back to certain values that guide the process. I think this is because the core values for most tribes are the equivalent of a constitution in a Western society. So we may not have a document that enshrines our core values, yet these values are passed on from one generation to another. And it's something that I just want to note is that it's not passed down through a document, because the point of having core values is walking those values, is practicing those values daily in our personal life, in our relationships, in our community. And that's why it's almost intangible, but it's too tangible because it shows up in our life, in our praxis. And again, I bring that back to ancestral praxis, because we have that memory in us and we practice it. And it's hard. It's very hard to walk that in the current state of the world. But just something to think about. So in this sense, for some legal thinkers, this might all sound woo-woo and mystical, yet the ancestral technologies and stories are also quite literal. There is a pattern that repeats over and over in many indigenous people's ceremonies. The circle, which is a huge aspect of restorative justice. The four directions, the four elements, plants as guides, and then us, or the leader of the circle, as a guardian, steward, or intermediator for that conflict resolution, which is built by everyone in the circle. So as we grapple with an ever-changing Anthropocene accompanied by climate catastrophe, I know some of these technologies are going to be needed. And by technologies, I mean the ancestral praxis that our ancestors gave to us, that are accessible to everyone, not just indigenous people on Turtle Island or in Mexico or in Latin America, but hemispherically. to all of humanity. So the Mexica call creator god Ometeo. Ome means two, and Teotl comes from Teo, which is God. To God. This acknowledges two deities of the Mexica, which are mother and father of all the Mexica deities, Ometecutli and Omecihuatl. Ometecutli is male and Omecihuatl is female. This dual god and almost all Mexica deities teach us about the creative and destructive force inherent in the universe. Conflict is an inherent part of creation, and that is why our ancestral praxis follows a cyclical nature. We are born, we grow, we flourish, and then we begin our descent. Likewise, the restorative justice process and circle follows that timeline. It's born, it grows, the circle is formed, the process happens, the conversation happens, then it flourishes, and then it begins its descent to resolution. And the beauty about that cycle in the restorative justice circle is that it can be revised, and it can repeat itself if the members are willing to make the work, to put in that work to restore that conflict, and ultimately getting to what that circle would consider justice or conflict resolution. But that is basically why I want to root us in the ancestral praxis of restorative justice. So thank you very much for coming here today. I'm very happy and looking forward to hearing my peers and colleagues in this beautiful convening.
Thank you, Anna. I am going to pass the mic to our next presenter, Grace Woodward.
Thanks, Leah, and thanks, Anna. That was really beautiful reflection. So my name is Grace Woodward. I'm a second-year evening student at the George Mason Antonin Scalia School of Law. I'm zooming in from Washington, D.C. I am a volunteer chaplain. I'm a pastor and volunteer chaplain at Georgetown, but I spend majority of my time as the Director of Restorative Justice and Diversion Services in the Arlington County Commonwealth's Attorney's Office. So Virginia's an odd state. It's actually a Commonwealth. So I work for the elected DA in Northern Virginia, and I identify cases to go to our restorative justice diversion program. So what I'm going to talk about over the next 10 or 15 minutes, the high level what I'm going to talk about is that how we can use restorative practices to meet this new ABA, the American Bar Association Standard 303C. So the American Bar Association has accreditation standards for law schools that they need to hit. And the ABA updated Standard 303 in February of 2022, requiring teaching in bias, cross-cultural competency, and racism. And so I believe that law students should advocate for this required learning through Standard 303C to occur in a restorative circle process. And I'll speak more about this, that RJ is so much more than just a traditional offender victim dialogue. Like Anna hinted, it's so rich and so deep. And so it's this posture, it's a way of being. And I'm going to go into why circle process is great for this kind of learning. So as Anna mentioned, RJ is really grounded in storytelling. It's grounded in who we are. So I thought I'd start with how I started thinking about this standard and how to incorporate circle processes into it. So like I said, I'm a second-year student at George Mason, and during orientation at my first, I guess, week of school, and I'm in a very conservative law school, and myself, I'm very progressive. And I saw on the schedule for orientation that there'd be a session on bias and racism in the law, and I thought, how exciting, that's great. And to my surprise and a little bit of terror, the professor that was selected or volunteered to lead this session began mocking discrimination and racism in the law. And he goes, it's like, well, what is discrimination in the law? Because a 14-year-old can't drive a car, but a 16-year-old can. And someone who's 20 years old and 364 days can't drink alcohol, but someone who's 21 can. And a kindergartner can't enter into a legally binding contract, but an adult can. So is that discrimination? Is that bias in the law? And he kept going, and he even went so far to say, there's not overt racism anymore. There's not racism in the law, whatnot. So I began thinking, why did George Mason even feel the need to have this conversation? What is going on? I just started digging. So I found out about Standard 303, the change, and that law schools are really trying to figure out how to incorporate it. So to go into a little bit of background about this standard, the text reads, effective February 2022, quote, "A law school shall provide education to law students on bias, cross-cultural competency, and racism, 1, at the start of the program of legal education, and 2, at least once again before graduation. For students engaged in law clinics or field placements, the second educational occasion will take place before, concurrently with, or as part of their enrollment in clinical or field placement courses." So there's a difference, there's a spread in law schools right now. Some schools, I would say many law schools, this standard just solidifies what they've already been doing. And especially since the uprisings following the deaths of George Floyd and Breonna Taylor in 2020, a lot of schools have taken these initiatives on their own to do this kind of training for students. But some schools, like the Antonin Scalia Law School, are just beginning to explore how to fulfill this new requirement. And I don't think that my school actually thought very hard about it. And that's how it ended up being this really disastrous orientation experience. So I think this presents a really exciting opportunity for law students, as all of our schools are thinking about, how do we do this education? What does it look like in orientation? And I believe that RJ is inherently liberatory, and the work that's requested of law students in 303C is this liberation work. So I think restorative justice is a great vehicle to do this kind of teaching, because restorative practices promote safe and transformational learning in ways that just standard lectures or presentations can't possibly do. And I've noticed that law schools seem to think that there are predominantly two methods of educating, of legal education: the lecture method that may have some Socratic elements depending on the professor, and an experiential and clinical element. It's sort of more like the apprenticeship model. But there's so much more available through circle processes, where each person, on a very basic level, when you're sitting in a circle, you can see each other. There's no desk or table blocking your body from their body. You can read body language, you can read cues in a way that you absolutely can't in a lecture. Each person in the circle process gets a turn to speak, and you can kind of tell when your turn is coming if you're moving around the circle, or if you're passing, there's a particular speaking order that you're aware of ahead of time. There's also, central to the circle process, is you can pass. If you don't feel comfortable or you don't want to speak, you can pass. So I imagine that folks in law schools and lawyers might say that this is not how the court works. This is not a useful skill for future lawyers to know. This is not real life. This is silly. As Anna said, this is woo-woo. But I think if we want to be able to use RJ in transformational ways in the criminal legal system and chip away little by little at the adversarial system, we need future lawyers who understand the power, the cultural power of the circle process. And so for these, to educate these future lawyers, we need them to be able to connect to each other and know what that feeling is like. So we can introduce this model and plant seeds for cultural change, whether or not they're going into criminal law or whatnot. I believe that it's this sort of seed planting that will trickle, whether they're parents and they have children in schools, and then they can advocate for RJ in their schools. I think it will really, really trickle. So it's really important then to identify who are the partners and the decision makers in your schools making these decisions about how this standard is going to be met. So I think a really good way to start is to connect with the work that's already happening at the undergraduate level in your university. So a lot of universities are trying to incorporate RJ into their student affairs processes, into their disciplinary processes. at the undergraduate level. Like I know at Georgetown right now, they're completely redoing their code of conduct and their Title IX procedures so that they can have restorative options for students if they so opt in. So you can connect with the people who are already doing the work at your university broadly, and then they can perhaps point you in the right direction of who's doing the work at the law school. I do know that a lot of universities, the law school is actually pretty separate from the undergraduate university for various reasons, but I think connecting with the work that's already happening is so central to the restorative approach and a good way to do movement building in general. Don't think that you need to build the wheel. So in that same theme, connect with local community-based RJ organizations where you live or where you go to school, if those are different. I would encourage you to share with them this project, this idea that you have for bringing RJ into legal education, and ask for their support in brainstorming. We have really amazing community-based RJ organizations in Arlington and in Washington, DC, and I work very closely with them. Similar theme. Don't think that this is all on you to reinvent the wheel. So then I think even narrowing in, identifying who makes the decisions about meeting this standard at your law school. So for us at George Mason, orientation is mostly organized by the director of admissions. I don't know if that's the same at other schools, but if you can just remember back to your orientation, who was sending you emails, and connect with them. Ask how they plan to meet this new 303C standard. I would also recommend connecting with your dean to ask, again, the similar questions. How do you plan to meet this standard? How are you thinking about it? And then advocating for the value of restorative-based circle processes to meet the standard. So I think your dean should then be able to connect you to whoever is actually the decision maker. And the dean at George Mason has been very open with me and taking meetings, and I imagine most of yours should be as well, even though it could seem very scary to just cold email the dean of the law school. I highly recommend it. So as you're thinking about, okay, this is great. I buy your argument, Grace. I think this is the right thing to do. I'm willing to talk to my dean, but what do I say? How do I advocate? What do I do? So I'm just going to go back to this point that RJ is held in community. This is a central element. Anna talked about this beautifully, that it's so grounded in the people and the place. So connect with the work that's already happening and ask for their support and build a coalition with your peers. There's lots of resources online. I personally go to Howard Zer's website. He's got amazing resources about RJ, what RJ can look like. They're great books. I think I actually have some of them above me. The Little Book of Restorative Justice, if you haven't read that, which is by Howard Zer, the Little Book of Circle Process by Kay Pranis. There are these little book series. I imagine many of you know about them. There's one specifically on restorative justice in colleges and universities that I would highly recommend. And then a great book that I've used a lot in my work is Colorizing Restorative Justice, which is a great collection of essays and whatnot about using really liberatory lenses when we're thinking about RJ. So it doesn't just become this really whitewashed phenomena. So read and take in as much information as you can, work with the work that's already happening, build coalitions, and advocate for the learning to happen in this way. And I'm happy to be a resource too, if you have further questions. So with that, I will pass to Jennifer. Thanks all.
Hey, can everybody hear me? Okay, perfect. So hi, my name is Jennifer. I am currently a 2L at Cardozo Law. I'm actually zooming in from Cardozo, which is in New York City. So my presentation will cover how restorative justice may be integrated into the curriculum for civil procedure. However, I do believe that a lot of what I'm saying will or can apply to any class that focuses on civil disputes. So for example, contracts, torts, property. I do draw on various sources for my presentation, which I sometimes quote directly. I am more than happy to share these sources with anyone. Please feel free to reach out to me following the panel. Okay, so what is civil procedure and why is it a required class for first-year law students? So civil procedure consists of the rules that govern civil suits, and these rules are compiled into what is known as the Federal Rules of Civil Procedure, or for short, FRCP. The civil procedure curriculum teaches students about the life cycle of a lawsuit. So from filing a complaint and conducting discovery to moving for summary judgment, civil procedure professors expect their students to become familiar with the FRCP and to correctly apply it to hypothetical scenarios. As the United States legal system is adversarial, learning civil procedure is essential for students, specifically those who wish to pursue careers in litigation. Moreover, civil procedure is a bar-tested subject, so students, whatever legal career they may choose to take, must display proficiency in the subject to become licensed as an attorney. So, why does civil procedure perpetuate the harmful effects of the United States adversarial legal system? Civil procedure at its core is about one thing: how to initiate and conduct lawsuits, which, as we know, are the core component of this country's legal system. Lawsuits not only destroy relationships, but also wreak emotional damage for litigants. It is noted that contemplating, undergoing, or having undergone a lawsuit is disruptive. The experience saps energy and distracts the litigant from the normal daily preoccupations of what we call life. Litigants who commonly feel alone throughout the litigation process may feel alone, isolated, and helpless, and are challenged to confront and manage the emotional burden of the legal process. This challenge may manifest itself as sleeplessness, anger, frustration, humiliation, headaches, difficulty concentrating, loss of self-confidence, indecision, anxiety, and despondency. Furthermore, the way litigation works in the United States, it often does little or nothing to solve the underlying problems that cause the dispute in the first place. Civil procedure, with its narrow focus on litigation, feeds students the myth that lawyers are required to protect their clients' interests by taking hard adversarial positions on the assumption that there are only two possible outcomes. Each side can win or lose, where there is a zero-sum relationship between the options, so that one party's gain inevitably results in an equal loss by the other party. The notion that there are situations that are not best resolved through this adversarial process is not introduced to students in their first year curriculum. Some students may choose to pursue and explore alternatives to litigation. However, for a lot of students, this myth is never challenged. So, as we know, restorative justice practices, restorative justice practices seek to harness the commission of crimes to the making of new opportunities for personal, communal, and societal growth and transformation through empowerment of both victims and offenders in direct and authentic dialogue and recognition. Restorative justice is a response to what is considered to be an overly harsh and ineffective criminal legal system, while civil procedure, as I previously mentioned, is part and parcel of the civil legal system. So are the two incompatible? It's my view that the two are actually compatible. So the success of alternative dispute resolution, or ADR, while not completely synonymous with restorative justice, proves that putting disputing parties in direct communication, as restorative justice does, works in a civil context. Furthermore, the objectives of restorative justice, so intending to promote healing at the individual and group level, and reintegrating wrongdoers into more positive roles and relationships, are goals towards which the civil system should aspire. So, which restorative justice practices and our principles should professors incorporate into the civil procedure curriculum so that students learn that client advocacy is not always a zero-sum game? While ultimately what principles a professor may choose to incorporate into their class is at their discretion, I suggest that they look to the practices of Indigenous nations as a way to honor the Indigenous roots of restorative justice. The Navajo Nation's peacemaking program would be an instructive example for students of how Indigenous nations successfully resolve civil disputes without resorting to litigation. So just a quick overview on the peacemaking program. It began in 1982 as a way for the Navajo Nation to move their court system away from a Western adversarial court model and towards a model informed by Diné wisdom, custom, and practices. The peacemaking process is available to disputing parties as an alternative to the Navajo Nation's version of the adversarial system. Peacemaking aims to get at the heart of the issue and guide people to adjust their relationships so that they return to good relations or build a new relationship if they did not have good relations to start with. The peacemaking process involves the use of a peacemaker who works with the disputing parties to lay out the problem and allows the parties to say what they feel about the problem and allows for discussion sometimes at great length. Then, using what is known as the planning process, the peacemaker will help the parties arrive at a solution to the problem. So while I believe the peacemaking program can be informative in any class that may deal with civil disputes, I also believe it's especially informative in the context of civil procedure. Because the peacemaking process involves no fixed rules of procedure or evidence that limit or control the process, participants are given the opportunity to speak freely about their feelings and offer solutions to the issue at hand. While it may be unlikely, at least currently, that the FRCP will be abandoned, exposing students to how the Navajo Nation's peacemaking works successfully without rigid rules allows for students to recognize that dispute resolution does not need to abide by such rigid standards in order to work. So, given the breadth of material that civil procedure professors must cover and the relatively short time they have to do so, how can they bring restorative justice principles, such as the Navajo Nation's peacemaking program, to students? Because in my experience, civil procedure was driven mostly by hypotheticals, or the class was, professors could incorporate restorative justice-based hypotheticals into their class. So even something as simple as X and Y entered into a contract and are at odds as to the interpretation of one of the contract's provisions. They wish to resolve the dispute, but cannot afford to go the route of litigation or formal arbitration. They come to your office and ask for your assistance. Using what you know about the principles of restorative justice, how would you advise X and Y? At the very least, professors could offer optional readings or materials for students to explore. While not all students may choose to engage with these materials, it presents an open opportunity for interested students to broaden their perspectives. Or professors could even dedicate a class to having a guest speaker, lecture on restorative justice. I think, in my view, that what the most significant thing is that professors present their students with the opportunity to challenge this myth that the adversarial system perpetuates and to learn of practices that really allow for better client advocacy. All right, and that is my presentation. Thank you so much for listening to me, and I will pass it along to Jordan.
A little bit of what each presenter has been talking about. I feel like I maybe have some point to touch on. Jennifer mentioned ADR. That's really some of the main focus of my presentation. I come at it from two angles. I think that ADR and restorative justice share a lot of fundamentals in common, and so it makes for a great entry point to incorporate restorative justice into JD curriculums. And I also think that because ADR is growing, and I'll talk a little bit more about that, restorative justice can grow with it. And similarly, it's a great entry point to develop new programs in law schools, enter into new courses, curriculums, and grow together with ADR. So ADR is alternative dispute resolution. I just want to make sure that we're all on the same page. I imagine everybody or some people have at least some familiarity. But just on a basic level, alternative dispute resolution encompasses three main things: negotiation, mediation and arbitration. And these aren't really so arbitrary of a group of 3 practices. They kind of come on a sliding scale of party autonomy, who is involved, what the process is, when the process can take place, how expensive the process is, but all of them are alternatives to litigation. ADR is all about finding an alternative to litigation for different reasons. So like I had said, in each of these processes, there is greater autonomy with the parties, especially in negotiation. That's the greatest level of autonomy that you have with parties. Arbitration, still more autonomy than there would be in litigation. The parties can kind of choose the process before the arbitration begins, but certainly you're leaving it up to the hands of the arbitrator. There's greater agency in all of these processes. They certainly have the capacity to preserve the relationship more than litigation would. You can choose which alternative process to use to sort of fit your dispute or fit the best form of resolution to your dispute. They're customizable, and people generally leave these processes with greater compliance. Whatever their agreement is, they stick to it, and they're more satisfied with the outcome, as opposed to if a judge had handed down a ruling and told them the same. A lot of these benefits kind of coincide with restorative justice. Some central tenets and principles of restorative justice is to keep autonomy with the people involved in a dispute or in the conflict. Help them maintain their agency instead of ripping the dispute out of their hands, putting it into the legal system. The judge is going to make a decision one way or another, and there isn't really an opportunity for alternatives. There's not opportunities for customizability, or what's best for the aggrieved or the offender. And these aren't really coincidences that these are similarities between alternative dispute resolution and restorative justice. They kind of share a history. It was born out of a movement called transformative justice movement. It started around the 1970s in the wake of the civil rights movement in the 1960s. So there were some things that were really abundantly clear to people as they reflected on the progress that was made in the civil rights movement and how far that the country and the justice system needed to go, even after the progress that was made. So some of the reflections that was plenty apparent to everybody was that there was a degree of state coercion that was unacceptable in the current justice system. Not just was there state coercion, the state and the justice system in many ways were one and the same, and there was an ever-present sense that this was illegitimate. This wasn't justice. It certainly was not justice for all. And so the transformative justice movement was one that wanted to revolutionize the justice system. It wanted to see justice put back in the hands of people and their communities. It wanted the communities to be responsible for the disputes and the conflicts within their own circles, putting the agency back in their hands and letting them be responsible for their justice instead of the state, who is both coercing them and lost their sense of legitimacy over years of abuse and etc. There is also the sense that justice in the hands of the community could involve some sort of social ordering. So there's a popular belief in, especially I think, conservative theory on justice and policing, that the more policing that can be done, the more safe that communities can be. The more that even especially petty criminals, as some of the theory goes, are taken off the street, again, the more safe that communities will be. But transformative justice really flipped that paradigm on its head and said, no, actually, we can conduct justice, for example, forms of restorative justice or mediation, as is more kind of in line with ADR. We could conduct those forms of justice in a way that is social ordering, and we'll be able to assure our own safety and that our communities are operating in a way that is acceptable to us and safe to us and just to us, by conducting these processes like mediation, like restorative justice. So those were some of the ideas that theorists in this social movement and legal movement were thinking as this transformative justice movement was gaining steam after the 1960s. But there was a point where there was a split in ideology in the transformative justice movement. And that's kind of where traditional legal ADR, alternative dispute resolution, started to become more coalesced as a field. It started to institutionalize. It started to become court annexed programs. There started to be organizations like the American Arbitration Association, just for an example of an ADR organization that started to institutionalize. They started to standardize their practices. They started to have their own rules. They started to have their own credentials and their own trainings for who could be a neutral, who could serve in these roles. And this was in contrast with the social public first mentality that transformative justice had started with. They wanted it to be informal, and not informal in the way that everybody kind of like sits around a table with coffee and snacks, but informal in the way that this isn't supposed to be a part of the state. This is supposed to be for the people and by the people. There was also a way that this was starting to get commodified. People were starting to make a career out of this, and there was starting to be a hierarchy of, you know, more renowned neutrals that were making more money for more higher profile cases, perhaps commercial cases. And it lost its sense of really this was supposed to be an operation that was for the people first and for its social ordering and justice. Also the privatization and the public, normative versus revolutionary was another big part of this. People in the legal formalist camp were thinking, well, we could use these dispute resolution processes to improve some of these systems that we have. The justice system isn't perfect, but we can make some sort of incremental change using these alternatives. But that was totally contradictory to the transformative justice movement. They wanted to revolutionize. They didn't want incremental changes in the system. They saw the system as broken. They wanted to take it out of the hands of the state and into their own hands. And so a massive split had begun at some point around the 80s, and it continued to transpire to where now alternative dispute resolution and restorative justice, although it might be recognized with some similarities, they're, I think, largely thought of as under two different umbrellas based on the practitioners that I had spoken to. So while ideologically they may have had this split, while they may have gone in their different directions, I want to harken back to these similarities there are in the fundamentals of the two practices. They do really care for party autonomy, for agency, preserving relationships and healing those involved, both the victim and the offender. They care to actually make sure that the method of dispute resolution or restorative justice actually fits the conflict. They care that it's kind of customizable in the way that it's going to care for this conflict. And they care that in ADR, maybe it's greater compliance, and restorative justice, maybe it's this idea of social ordering, that they're actually getting their communities to be just in the way that they are. So I kind of point out some of these similarities to show that contemporarily, both restorative justice and alternative dispute resolution fill in some of the gaps that modern litigation and the modern court system leave open. There are significant delays in the modern court system. I can't say that I'm too familiar with the span of time that it might take for a restorative justice process from start to finish, but certainly in alternative dispute resolution, that's one common advantage, is that it's taking much quicker than it would take to go to trial. There's this idea of this dissonance in a trial and in the traditional litigation system where the victim may never even come face to face with the offender. And it's this impersonal process where the judge is handing down the decision. It's these people, it's these strangers, it's nobody from your community. And both ADR and restorative justice do a better job of bringing the victim and the offender into the same place to really help both people heal and move forward from their conflict. Similarly, they both get a lot of the similar criticism. People ask, well, does restorative justice work? Does ADR work? Why are we assuming that forgiveness and reconciliation is possible? You know, could it just be that there needs to be this adversarial posture? It also seems that with this informality, with keeping it in the hands of the community and without these standards, couldn't people abuse the system? What if people that are in a restorative justice process or in ADR are in there in bad faith? Where's the accountability? And what if punishment is necessary is another criticism. So I see the two as very intrinsically connected, both from their history as well as the fundamentals that both practices keep at their core and move forward with. So I had also talked about how ADR is growing. There is a movement now how the legal profession is kind of aligning with some of these principles that I was just discussing. I forget which panelist earlier was discussing the model rules that the ABA is putting in for legal education, but it's happening both in legal ethics and in legal education. So one idea in legal ethics and professional responsibility is serving your client's best interests. So what if litigation just isn't the best option? For a very long time, litigation was the only way that you were serving your client's best interests. But in reality, there's lots of different alternatives. So legal ethics and the professional rules and ethics started to take on a new posture. And it was that you must advise your clients on the dispute resolution options available to them. And you have to suggest what might be reasonably pursued to attempt to resolve the legal dispute to reach the legal objective sought. So that also takes a certain level of competence. You have to know what the alternatives are. So in a step in that direction, the ABA and the bar exam are adopting ADR into the 2026 bar exam. Students are now going to have a basic level of competency to be able to give this advice to their clients starting in 2026. Importantly, though, this is just the civil sphere. There's kind of a big dichotomy between the civil and the criminal sphere. So this is an excerpt from the professional rules of ethics for criminal prosecutors, that prosecutors should act with integrity and balanced judgment to increase public safety by pursuing appropriate criminal charges of appropriate severity. It also says that they should be familiar with non-imprisonment sentences. So this kind of seems like, well, restorative justice could be an obvious way to abide by these ethical ideals. But the realities are pretty different. Prosecutors really don't have any obligation to use these alternatives. There's this perception that the alternatives are really ineffective, that they're not executing justice. And the realities around election politics and district attorneys is such that they have to capitulate to public opinion that may not be in favor of the more progressive forms of restorative justice, and the perceptions that those aren't effective to punish perhaps criminals. On, again, the criminal side, but on the flip side of defense counsel, the excerpt says that defense counsel should be knowledgeable about dispositions that are alternatives to trials or imprisonment, including diversion from the criminal process. So again, this seems, well, restorative justice is perfect here. Why aren't we using it more? One big issue in the ethics is that a lawyer must also act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. The zeal and advocacy language is really problematic for defense attorneys who might want to use restorative justice. There was a seminal case called Gideon v. Wainwright. This is an excerpt from the case where the judge said, in short, the collaborative system, speaking about restorative justice, the collaborative system practiced in community courts is antithetical to the defense function. It co-opts defense attorneys into prosecutors and judges' task of doling out punishment. Basically, what the judge is getting at here is you can't be a defense attorney and zealously advocate for your client at the same time. They're incompatible, is the view of the Supreme Court. If you're zealously advocating for your client, you won't almost sell them out is the perception to these community courts. You're going to try to prove them to be innocent. Again, the reality is very different, unfortunately. So I'll wrap up with some conclusions, refocusing on the question of how we can incorporate restorative justice into JD curriculums. First is to include restorative justice into ADR programs. They share the same fundamentals. They share the same goals of processes. And now as ADR is growing and increasingly going to be prominent parts of JD curriculums and law school programs, restorative justice really would find itself comfortable under the ADR umbrella and developing its courses and its lessons within those programs and courses in ADR. Lastly, I would say that restorative justice ought to be included in professional responsibility courses. I think that it's pretty standard that to get your degree, to fulfill your requirements, you need to take professional responsibility. And while the civil side has done a good job of catching itself up to speed, saying attorneys need to be competent and advising to these alternatives, the criminal side has really been lagging. There has been no developments that are urging attorneys to start to advise their clients on these criminal alternatives, especially restorative justice. But it's in there in the legal ethic code. It's what we aspire to. So I would recommend bringing them into professional responsibility courses. So that's what I have to say. I know that we're going back in circle format, but I also want to keep an eye on time. So I'm not sure if I should pass it back to Anna or.
Yeah, thanks, Jordan. I'm going to go ahead and take back over, and we are going to move to our open Q&A time. So go ahead and use the chat function to ask questions of specific panelists or to the panel as a whole. And as folks are typing questions in the chat that they might have, one question that I have for everyone is, what are some of the benefits and drawbacks to incorporating restorative justice into courses or something like orientation where all students are being exposed to restorative justice, contrasted with implementing restorative justice specifically for students who might already be interested in learning about restorative justice, like an ADR course?
I can just go ahead and get started. I think one of the drawbacks of trying to implement restorative justice into like a regular doctrinal course where there's a wide variety of students is that there may just be students who just aren't interested in learning about restorative justice. And I feel like that may in some ways hinder other students' ability to really engage with the material that they're being presented. Yeah, I think that's one difficulty that I could potentially see, though I am definitely an advocate for trying to incorporate restorative justice in whatever way into doctrinal classes.
The first thing that came to mind with that question, Leah, for me was that, I mean, I'm very supportive of putting it in a touch, like a place that's going to touch all students, because I think that furthers the message that RJ is not just like an elective or like a nice little thing on the side, but it's a posture, it's a way of being, it's a practice. This is what I say all the time at work. I'm like, RJ is not just a diversion program. It's an entire way of being in our office. It's how we relate to each other. It's how we think about cases. It's how it's a posture. So I always say, RJ is not a program, it's a posture. And I think if we can convey that to law students, hopefully it will be impactful and avoid. I mean, when I was in my first graduate program and I was in divinity school, and I argued with people too, that's like, well, we have like the canon of ethics or the canon of theology, and then we teach liberation theology on the side, and then we teach womanist theology on the side. It's like, well, what if we just actually fundamentally rethink the canon? So to me, this is very similar.
Yeah, I completely agree with that, Grace. And also, I think this kind of sums up what we've been talking about. The current legal system is the adversarial system is anti-intuitive to us as human beings and everything that surrounds us. It's not helping us get anywhere where we flourish, where we thrive, just, within our communities, within our families. I mean, some people thrive because it works for them, but not for most of us. So it's anti-intuitive. And I think that goes back to the question of, fundamentally, we know that this legal system is a construct. We know that this legal system was made up, and therefore it can be revised, it can be replaced, and it can be acknowledged for what it is. And I think when we come into law school, it's a culture shock, because we know that it's making us understand that the system is working exactly how it was supposed to work. When we, like, for instance, and we've been talking about this a lot in this semester in my class, a class which is called Indigenous Peoples and Colonial Law, which is sort of like touching upon federal Indian law. But my professor, Natalie Segovia, who is the director of the Water Protector Legal Collective, she said that it's like federal Indian law is if we see it as a branch, as a course that's like on the side, it's like it's basically calling the branch the tree, because we know that federal Indian law is where most cases is where the foundation of private property is, the foundation of land, like stealing land, amassing wealth, privatizing, then the treaties, then breaking the treaties. And so, like, all of that history, it's like indigenous people's history on Turtle Island is American history, and so that's the tree, that's not the branch. And I think that's something foundational when we go into law school. We're sort of confronted with the choice. Do you want to go the route of of buying into, or accepting, or sort of indoctrinating yourself into this system that is completely constructed on violence? Or do you want to go the route of going against the grain of society and everything that we've been told that is true, that is real? And I think that is the challenge of restorative justice in itself, because as Grace said, it's not like this little cute thing. Like, the class that I'm taking this semester on Indigenous Peoples and Colonial Law is not supposed to be an elective. I think it should be, a course that is required for everyone to take, because that is the foundation of the system. And until we confront that, can we, move towards restoration? Because before restoration comes truth. That's why there's truth and reconciliation commissions, and I think this country is in urgent need for a truth and reconciliation commission. But that's like another conversation. But yeah, I think that is, it should be both. It should be, in like an analysis engraved in doctrinal courses, but it should also be presented at orientations, because I don't think that it can, it's not on the sidelines, it's foundational.
Sorry, this is Catherine. I dumped something in the chat, and I feel like it speaks to what we're kind of talking about to some degree, and what it reminded me of is, so I worked a lot of years in reentry services in the nonprofit side in New York City, and when I first started in that, I would meet with people who would refer to themselves as abolitionists of the criminal justice system, and that was a very scary word to me when I first started out in nonprofits, because it sounded like just the complete removal of any sort of law. But the more you talk to and the more you engage with people who really promote the abolitionist thinking from a nonprofit view of reentry services and criminal justice reform, the more you realize it's essentially having a criminal justice system that works for the most privileged people in our society, the same way for everybody. and just really, really pinpointing the purpose of the criminal justice system. Is it really meant to be punitive, or is it meant to be protective, or is it meant to be educational? And really engaging from that perspective. And I won't lie, I am a brand new baby. I'm like 1 month into law school here. But I'm coming at it specifically having worked in reentry services for quite a long time. So to me, everything looks flawed. I guess like I feel a little bit bad. They had that question the first day where they're like, hey, do you think the legal system works well? And I'm like, no, have you seen it? And I think trying to engage people on those conversations, part of it is starting to use those scary words right at the beginning and explaining to them what they really mean and what it really means to talk about a criminal justice reform movement that would take it down to the bare bones if it had to, or even get rid of the system as it currently exists if we need to, in order to just really get to the core of what do we think justice is. And to talk specifically about just the level of mistreatment that currently is involved in it, because it's pretty profound. I'm sorry if that just seemed out of, I felt like it was relative to what you were talking about, and I wanted to make sure. I'm sorry, my camera's off. Cats room.
Yeah, thank you for sharing that, Catherine. And I noticed your question in the chat, so maybe I'll go ahead and shift to the question you asked, which is, what is the role we see for any reentry or preventative services in the sphere? Do we consider the punitive impact on families when we're looking at the purpose of the system? So if any of our panelists want to share any thoughts about those questions.
Yeah, I'm happy to get started there. I think that's an excellent question, Catherine. And one thing that I love the community-based organization model for all prosecutor-led diversion, which prosecutor-led diversion is a hot topic right now, and I'm biased because that's where I work. But the idea of having restorative justice in a CBO model, which I'm sure many of you know, is that so a case comes through the criminal legal system, prosecutor identifies it, diverts it to the CBO, who then does the restorative justice process. So it's taking power away from the criminal legal system, shrinking it theoretically and hopefully in practice too. But then what's so brilliant to me is that in the future, if someone has an instance of harm, they don't actually have to call the police, they call the community-based CBO. So that's the asset to me of having a nonprofit that's really based in the community, that potentially it's actually building the infrastructure for an abolitionist future where people have options when there's harm and crime, that they have options of who they can call and who they can engage with that's not 911. So I think like these nonprofits focused on preventative services are huge. Reentry, yes, but more of, I'm sort of more of the preventative side, but of course we have folks incarcerated that need support as they're coming out. But yeah, that's like to me the cornerstone of the abolitionist future.
I can jump in to share some thoughts, because I think that the role of NGOs is it's a double-edged sword, and I've kind of been both like inside and outside of it. And I used to work with NGOs on immigration, and specifically on immigrant detention, working with women and children in detention centers. And why I say it's a double-edged sword is because on the one hand, there's this, and it's very similar to a legal like positionality. You're like mitigating harm, But on the other hand, there's this huge amount of wealth being channeled towards NGOs that, have the commitment to, for instance, represent families in detention or advocate for policy change or whatever. But all of those resources don't go actually to the community, but to creating jobs in the NGO world that are supposedly working with community members who are, and empowering. And I think that's where the double-edged sword comes from for me, because I ask, why wouldn't it be better to invest those resources in the actual communities? And I think that's where, Grace, you referred to the community model. I think if an NGO is working in that community model, it's much more in alignment with the community's goals and purposes, but I think that this notion of having an intermediator is where we have to reflect on how those resources are being used, because often when we look at the impact, for instance, of NGOs, it's like really good on one side. It's like, for instance, you get your green card, but on the other hand, you're still facing labor exploitation, housing insecurity, food insecurity, and so all of these things, I think when we look at the community itself, if the community was getting the resources that are instead going through philanthropy and NGO, if those resources were invested in the community directly, then the impacts would be, I think much more visible in the community, not to grant makers, not to the NGOs themselves, because these changes are also a lot of times not quantifiable as we like them to be. But I think that's something that we need to ask ourselves, is how much resources are being invested in NGOs for doing this kind of work that could instead be given to community members directly, organized community members, because I think that's a huge part of it. People are burnt out. They don't have the resources to be organizing in their community the way that they want to be, and I think that's another big issue there. But yeah.
Thank you. That's a very important point.
Thank you for those thoughts. I think we have time for one more final question. And this is open to everyone, but Jordan, if you have any thoughts, maybe I'll pass to you for the first chance to answer. And the question is, what response do you have to professors who might have pushback in implementing restorative justice in JD curriculum based on a concern or thought that they already have too much content to cover and not enough time to cover it, especially in, a doctrinal class or a class like professional responsibility?
Yeah, that's a good question. Excuse me. I think that professors will always have too much going on. There's an unending amount of material that you can cover, and no professor gets through everything that they can cover, everything that would be useful to students and future professionals to cover. So I think that kind of looking at that reality to start. Second, I think that maybe the orientation I was giving towards the professional code of ethics is maybe a similar approach to take with professors. And I don't know if this happens in like faculty meetings or what, but looking at maybe the school's mission or the mission of professors and teachers and educators to say, well, what do we want to accomplish here? And how are we going to best prepare the future, I don't know, officers of justice, to like borrow from a term in professional responsibility? How are we going to prepare them to really be these officers of justice, and in a way that really looks at it from all sides? I think that it's a very practical and important point that if professors could make time for, I don't think that they would regret it. And the information that they don't manage to cover, students will have to study anyways for the bar exam or for the MPRE anyways. That's what I would say.
Just to jump in, I also think if that were true and that a professor really just did not have the time to cover restorative justice, there are other things they can do to introduce restorative justice to students. And I think that sort of goes back to what I was saying, like you can offer optional readings, you can put students, in contact with, different restorative justice organizations, point them to like restorative justice events. And not having the time, I don't think that's a very good excuse that shouldn't prevent you from at least presenting students with opportunities to expand their perspectives. I mean, professors, and especially professors for first year law students, I think are really fundamental in shaping students sort of like, I guess, I don't know how to put this, but like legal brains, if that makes sense. And so I think it should be a priority for professors who may not have that time, in class time, to dedicate to restorative justice, to at least provide pathways for students who may be interested in learning more about it.
I think it's challenging. Like if a professor said to me, "Oh, I just don't have enough time," I would probably ask them, like, I mean, do you actually not have time, or do you just think this is dumb? Like, there's probably a softer way to ask that, but I find, especially at the Scalia Law School, that professors want to teach there because they fundamentally believe in the system. And I know I have like a very conservative professor base at my school, but I imagine and someone can push back on this, but like to be a law professor, you have to like kind of believe that the system works. So suggesting RJ, which says that maybe the fundamental principles of our criminal legal system are not quite what we were sold, can be really existentially threatening. So this culture change of restorative work is really challenging, and it's I don't like to think of myself as an incrementalist, but it is like a incremental culture shift when it's so existentially frightening to people who have committed their life's work to this system. So tread lightly, but convicted.
Can I jump in with a response? This is Inga. Hi, team. I'm sorry, my screen is over here, but I have to look over here to talk to you, to look into your eyes. But I just want to say, like, as a law professor, everything that you've said really resonates with me and feels very true. And just to go even further into like the structural barriers that exist, everything is oriented around, right, the bar exam, passing the bar exam, although we'll have the next gen bar exam, but all measures of success are driven by scholarship. Tailoring classes, a criminal law class that has 3 credits, so that it can fit into the prescribed time to allot to all of the other subjects. So it's just the inertia of everything that really is in these schedules. So when you say paradigm shift, I mean, that is how you have to think about it. It's a complete restructuring of all of the economic incentives for professors, of all of the what's valued in terms of teaching. Everything is always like, oh, well, you can do that, but it's extra. And how is a student that already has so much on their plate supposed to consider these ideas as extra when they're just trying to sort of deal with what they already have? So it really is just so deeply inherent and baked into like every structure, just to teach the status quo of what we have, or maybe like what's one shade off the status quo. So I just wanted to sort of validate what everybody's saying.
Yeah, thank you so much. Yeah, and with those closing thoughts, we're going to go ahead and transition to a brief break before we move to our next panel. So thank you to our 4 panelists here. Such great ideas that you've shared with us and given everyone a lot to think about and reflect on. And we will have breakout groups later in the symposium to really flesh that out even more. So we're going to go ahead and take a 12-minute break. So if you all could come back on the 45 mark, we'll go ahead and move to our next panel. Thank you. Okay, everyone, welcome back. We are going to jump right into our second panel for the day, which is going to focus on how restorative practices can be used in law school communities to impact institutional culture. We do have a last minute change to this panel. Unfortunately, Jalen McClinton, due to an emergency, is no longer able to join us. And so we will just have 4 panelists this afternoon. We have Emma Teese, Taylor Fauntleroy, Aisha Reed Foster, and Emily Winter focused on this question today. So I will go ahead and pass the mic over to Emma, who will present first.
Hi, everyone. I'm not sure how the question and answer is going to go, but if you have any while I'm speaking, just shoot them at me or in the chat, and I'll try to touch them before my 15 minutes are done. I wanted to start off by just breaking down how I got into restorative justice and what I've been involved in, just to give some background. My mama actually introduced me to restorative justice. She gave me the little book of Circle Processes by Kay Pranis. So I was introduced to this idea at a really young age, which was awesome. I feel like it was intuitive to me and has really completely shaped my career path. And then I went to NYL, that's New York Law School, and they have an amazing restorative justice program. If you haven't started law school yet, that's a plug for them. Their professor, Susan Abraham, has really spearheaded a ton of opportunities there. While I was there, I was taught circle facilitation, a general restorative justice class. I got a restorative justice externship and was able to do an independent study paper on restorative justice and reproductive justice. So definitely a plug for New York Law School if you are interested in restorative justice and the law. And then to get into the meat of things and why we're all here today, I'm coming from the context of going to law school during COVID. I started in 2020. So obviously law school has its hierarchy, natural with academia. You have your students and your teachers, but also in the dynamic between the students and other students, just based on the curve and just the heightened pressure of ranking. And you know, GPA is important in our field. It's not something you can just shirk off. So it definitely adds a competitiveness, and it makes it, I felt, a little bit difficult to connect with your peers and build those connections, which is a big point of going to law school and getting that degree, is networking. And these people you'll pass in your career path the rest of your lives. I already am, and I just graduated. So I think the first thing I wanted to discuss was delving, like I said, more into what the current culture is. And it's a lot of insecurity, right? It's you're pinned up against each other, and you don't really want to go to each other for support. You feel that you're up against each other. And then not only that, when you're in the classroom setting, there is this Socratic, hopefully, dialogue going on, but it's almost hostile. Everyone's on edge, and you really are not eager to participate. It's kind of like, okay, I hope this is the last thing I have to do today. So what do we want? I think we really want to create more of an environment where people feel open to sharing and excited about participating, so we can actually engage in meaningful conversation. And obviously restorative justice could be really invaluable to that. One suggestion could be at the beginning of the semester, where you're just kind of meeting each other, and if you either do nothing at all or some kind of awkward, say a fun fact, which, like, my life is not that interesting. I'm just going to talk about my dog, and then I do yoga, and you know, you don't really get to dig all that deep. But if you started, let's say, with a restorative circle, solemnized the moment, grounded ourselves with something, and brought our values together, I think that could really, really help. For example, I just started a new job, and I think they're really great about trying to involve restorative principles, and they weren't even outward about it. They just kind of had us all talk about, in a circle, one by one, what brought us to the position that we're at and why we chose to be here. And then they reflected on that after we went around and just pointed out how the things that we named are the values of our community. And so it doesn't have to be anything formulaic. It can be really casual. You don't have to, like, it's great to name it that it is, that we're doing restorative justice, we're doing restorative practices, but you know, especially for people who may not be as familiar or open to the idea, there are ways you can be sneaky about it. And then on top of that, I think it could really help with just learning the material as well in day-to-day settings. So even at the start or the end of the class, to review the material in a way that actually discusses the impact on our personal lives, and ways that we can use it for basically our own liberation. We sometimes just absorb all of this material, and for what? And what are we taking this all in for? And how can we relate it to our lived experiences, and also bring in our full selves to the moment, rather than just showing up in what is often a purely logical exercise. There are so many nuances that can really add to our value of analysis, rather than detract. And like I mentioned, this is probably a great icebreaker as well. Like I said, you're not excited a lot of time. I didn't feel this way. I shouldn't talk for everyone. I was often not excited to talk in class, especially in a big, overwhelming lecture hall, where you're getting cold call. So just to have these circles that kind of have you speak up just once, to have your voice heard by everyone, can kind of ease the nerves a little bit. I would find, at least. And give a little context for each person. You're not just seeing them as your rival or competitor, which, like, hopefully we're not, but it's that pressure is always there. And on top of that, I think it gives a better understanding of what we're learning. It's really going to hit home. If it's just something that you're talking about in theory, I'm going to forget it. If it's something that I can relate to my personal life, or my friends or my classmates, peers that I deeply care about, that's going to stick with me a lot more effectively. And I think that it also could help bridge that divide in the hierarchy between students and teachers. That can be always intimidating. And I think it is really invaluable for professors themselves. I feel like it gives them more opportunity to, when they're just maybe saying the same information to classes after classes, it gives more opportunity for the students to give more nuance to their work as well. And beyond even just the benefits for the law school setting, I think that with the shifts in technology that we're seeing, this is ultimately going to serve us when we do end up out in the field. We have AI, ChatGPT, all of that. So I think that really where our skills are going to stay relevant as lawyers is these critical thinking and real life empathy and nuances. I can spit out a bunch of facts, and so can a computer, but they aren't going to be able to bring that lived experience. And I think it also gives an opportunity for us to kind of challenge the status quo. I think a lot of times we are just absorbing what is the law and giving it back to our professors on exam day, and having the space to critique and question what the powers that be say is so. Like, let's take back the premises before we even get to the conclusion, and really dig into that. And restorative justice provides an awesome opportunity to do that. And I think it also can help us be a lot more problem solving and forward thinking than reactionary in a lot of work that we do. I mean, we were just referring back to precedent a lot of the time. And when you get that chance to really think through these problems, maybe through a conversation in a restorative circle or dialogue, I think that could bring about a lot of positive change. So that's my piece. I'm going to be passing it on, I believe, to Leah. Why don't you correct me? I don't want to say the wrong person.
That's okay.
Thank you so much, everyone.
Thank you, Emma. So I'm going to go ahead and pass the mic over to Taylor.
Thank you, Leah. And then who am I passing to afterwards, just so I know as well?
Yeah, thank you. Good question. So you will pass to Asia.
Perfect. Hello, everyone. Let me get a moment to just share my screen with you. Ignore my bangles in the back. I might take them off because they're making noise. Okay, are you all able to see my screen and me now? Okay, cool. I see Emma smiling. I'm gonna take my bracelets off because they're distracting me. For whatever reason, I have I'm sweating from anxiety, and that never happens. And this is like a community and space of people whose faces I know, whose names I know. So I really appreciate you all being here. I'm going to, okay, my slides are showing. Can you all still see my slides? It's the same screen, nothing weird. Thank you. All right. And I just got the hookup on how to use the remote to change the slides from my phone, and I'm mind blown. So 15 minutes is not a lot of time. Thank you so much, Emma, for passing it to me and really setting the stage for folk. I think most of us have some type of encounter or idea of what restorative justice looks like, but I did invite a few people from my school community who I know are not as familiar with what restorative practices look like. So greetings again, my name is Taylor Fauntleroy. Let me pull up. And before I start, I also just wanted to bring some of the values of presence and gratitude to everyone today. With the screen this way, I can't see all of your faces, but it's all good. And I just ask that you extend me a little bit of grace in moments where I either speak in the first draft or need a hand and ask somebody to share a quick experience, because that's usually what I do. I'm a former K-12 educator and I miss the babies every day. But I'm currently a 3L and I completed my master's in RJ after my 1L year. Similar to Emma, I also started law school online during COVID, and it was a very interesting experience. It was obviously amidst the killing and then subsequent trials of related to George Floyd. And for some reason, I thought that this would be the lens through which my legal studies were taught, right? This advocacy-based perspective. And like I said, I was a former educator, and I had taught a whole bunch of different grade levels, but one of the main things, one of the main teaching principles that I remember was that a central pillar to keeping material engaging with students was to make it relatable and reference current social ongoings. So kind of with this in mind, I was shocked that the environment that I for so long associated with training social justice leaders and civil rights activists and advocates for change were kind of just carrying on business as usual, and hadn't made any very specific references to what we all saw, or what I perceived we all saw as a social injustice. So through kind of some of this frustration and adapting to a new learning curve, I experienced, some anger, a bit of confusion, great feelings of isolation that some of my peers also mirrored, even in our virtual settings. Like, you could see that people were very weighed and boggled down by our circumstances at the time. And with a background of trauma-informed learning, I was a bit confused as to why these practices weren't being integrated in teaching law. So I'm gonna go into my little, trying to do things last minute. Next slide, y'all see the next slide? Cool. Okay, so kind of a macro overview of what trauma-informed practices are. Before doing that, I want to give folk a brief overview of what trauma is, right? So we've all kind of heard, of course, the word trauma and associated it with an array of behaviors and mindsets. And while trauma is this complex psychological condition, for our discussion today, I just really want to think of trauma as an emotional response to distress. And what distinguishes trauma from, I guess, general adversity and feelings of adversity is that there's a lack of resolve that causes the trauma. So adversity becomes trauma when it goes unresolved or unaddressed, and there could be a number of outward manifestations of that trauma. I think I'd say that the concept that most of us are familiar with are like fight, flight, and freeze, right? So for purposes of just this short discussion, because we don't have a lot of time, and I hope someone keeps me honest with that time, but for purposes of addressing trauma in educational spaces specifically, I think that it's important to take note of the fact that because of just the admission process to law school alone, it's likely that those of us who've suffered trauma and are simultaneously in these settings and in these spaces have been the ones who have in the past froze or thought that we were fighting in some way, shape, or form, perhaps strategically, and then that prompted us going to law school. And then we also have, which I think a couple of the other panelists mentioned, our character and fitness screenings and the like. The legal education setting is on its face not very inclusive or empathetic to other outward manifestations of trauma. And this in and of itself can be re-triggering or activating for a lot of people who are struggling with that adversity of being first-generation law students or just some way, shape, or form still experiencing and re-experiencing that trauma, and who may adversely respond in a way of seeking out unhealthy coping mechanisms. And we'll get a little bit more into that. But understanding trauma-informed teaching, therefore, must require educators to kind of what I refer to as speak a different language, with this precursor of emotional suppression, fear, unresolved trauma in mind as they're teaching through these separate lenses. And I think that this is such a powerful tool because the ability to learn itself is not like a fixed concept. And that's why I had that little quote there to remind me, but like the ability to learn is not a fixed concept, but defenses that our traumatized minds can posit put up a cap on how we learn and how we interpret that information. And this little remote thing might not be, I'm trying it, y'all, bear with me. Okay, I'm hoping it's on the next slide, the where. Leah, give me a thumbs up if it's on the where.
I'm still only seeing your title slide, actually.
Awesome, good to know.
Okay, there you go.
Okay, yes,
Yeah,
so you guys
great.
missed this one. Sorry, this was the what. And those were all the things that I was mentioning. So, and I don't think we have just the time to really delve into what these types of trauma entail and what their responses can be. But some of the things that I mentioned in terms of just wanting our professors and other people in academic spaces to know that they exist is very important. So the where, and I'll just go back and forth between these two. So as I mentioned, I spent most of my professional career to date in an array of educational settings, although I wasn't teaching at every point. But as somebody who just loved to learn, I'd always had an admiration for teachers and just kind of the power that they held in the classroom. And also, once I became an educator and started to become trained in teaching K through 12, you learn the history of teaching, and so many restorative practices are already there. So Emma was mentioning, problem solving, like knowing how to problem solve and teach that is a skill. Also having circle-based discussions, that was something that was definitely heightened in K through 12 teaching. But the biggest modality to me was the storytelling, right? And we can get more into that later, but educators just have this power to draw out the strengths in us and help to foster these ideas, right? So at different stages in our lives, they can shift how we see education, either as a restrictive construct or a welcoming environment. And if they so choose or fail to choose to decide on a particular lens to have a teaching style, educators then have the power to kind of reinforce these indoctrinated principles of perfectionism, elitism, individualism, all the isms that I think a few other panelists described that become, at the very least, overbearing in our educational environments. And if that latter lens is the one that is taught through, I think that prior trauma or not, students are going to feel overwhelmed, unseen, and that can shape their sense of identity in an unhealthy way that's tethered to these standardized educational outcomes. And again, teachers just have the power to shift that in their classrooms. So we see some of these detached teaching modalities when we review cases about abuse or sexual assault with no type of trauma-sensitive language alternatives. When people have absences for COVID that are not excused, and we understand like there's a required number of classes that you have to attend before the bar says, your time is up, or you have to take a course again. We also see it when there are like feedback loops for professors that are very vague, where you get a screening of your professor and it's like, did you like this? Did you like that? Okay, any other comments? And the box is this big. So those things can make people, especially if they have been in isolative environments before or felt unseen, be re-traumatized again. So I think that is, and again, Emma did speak to this, I think that's an unfortunate reality for some of us who are now generationally going through law school, is that also in some of our K through 12 environments, we didn't have social, emotionally aware environments where our professors, teachers gave us that room and kind of institutionalized the moment to breathe and just be with yourself and be with other people. It was kind of this fast paced, ready, stop, go. So while these, so the epigenetic and kind of vicarious trauma that I mentioned before, while they don't always occur in the classroom, they often do transfer there and fester there, and they're reopened and reactivated there. And when this happens, it's kind of like a depleted sense of resilience that, of course, we need to just be legal professionals. So you're seeing the who slide, because I see the who slide. Cool. Let me see. Okay, yes. And this brings us just to like some of the nuances of who's impacted by their unaddressed traumas in the classroom most, I think most prominently, and based off of some research that I'll get to later. And I was just checking the time, but many of us are, in some senses, actually motivated by our trauma. And we're also, because of the spaces that certain types of trauma occur in, we're often commended for those motivations more frequently than that we're actually asked to be transparent about the adverse effects that they have on our lives. And that would be completely transformative if we did have those spaces in legal settings, not just in isolated professors' offices, but just as a cultural norm and standard that we have. In order to begin to kind of implement trauma-informed practices in educational spaces, I think that it's so important that we first understand the varying ways in which trauma manifests itself in individuals, right? So that's why I have those separate groups up there. Just keeping in mind how re-triggering some of these spaces can be if, for example, you're a first-generation student and you have immigrant parents coming from a Caribbean household myself. The expectation is just you constantly succeed. You don't get a pat on the back. Your parents still love you, but it's not always seen as this huge accolade or that you actually put the work in. So that internalized idea of perfectionism, when you go into a law school community and environment that's reinforcing that, and you have your curve, you have, like Emma also mentioned, the competitiveness between your peers. I will also say, and I saw some of my old professors from the March program up here, and it just lit me up. That was never the classroom environment. Even though we were virtual, it was always so welcoming. I knew that I could go to my peers. So it just goes to show that it's not just because we're at a graduate or professionate level program that, oh, it's so difficult to implement these things. It really is this indoctrinated principle of we are going to continue to reinforce ideas of perfectionism, hierarchical classroom settings, nepotism, competitiveness, but there is a way to shift that. And then I did also just want to briefly note a note that I made for myself that studies have shown that these values that are upheld that I just mentioned by educators most significantly impact those of the global majority. So being non-white students and those who identify as LGBTQIA. And that was the who, and we're at the why. And I'm just going to give folk a moment to look over some of these statistics and statements. I feel like these are things that we have heard throughout our law school experience, and we know to a great degree because you have PAL come in, you have specific offices within the law school like career services or other resource-based offices will do their brief discussions about these are the resources that are available. But again, with restorative practices, this has to be an everyday cultural ideology and concept and practice. So as we kind of consider these internalized and suppressed traumas that are reinforced in our learning environments, I think that there were a couple, and I'm just gonna pull my slides down so I can see how much time I have before I get to chatting. I think I got 5 minutes, Leah?
Yeah.
Okay, but there were like, the reason that I chose this topic specifically, trauma-informed practices and learning, was actually after the end of my 2L year where a classmate of mine developed a drinking problem following his time throughout, I would say, taking family law. So that was his first introduction to like the ACEs study, so adverse childhood experiences. And we had a conversation, and he was like, I racked up like a good 8. And I feel like most of us are familiar with kind of that scale of adverse childhood experiences. And for him, he said he literally just would shut down in the middle of an exam and think about abuse and neglect that he'd experienced and witnessed. And I let him know in advance that I would be sharing this experience with you all. But I think that that is just a stark reminder of the importance of restorative practices in teaching, such as, like we said, that the same way that in RJ we have person-centered language, I think that it's crucial that we understand trauma-informed language as well. And it literally is a separate language. And let me see. Okay, I think, yep, and I'm the last one. So a common thread for some of those anecdotes that I was going to mention, but didn't get to all of, I felt like that one was one of the most stark for me, but a common thread through a lot of the feedback on the educational environments that I've heard from my peers in law school is kind of this apathy and these feelings of frustration and fear, and not only feeling like they don't have the supports within the school because of the competitiveness that is a reality or has become a reality, but also because when they have reached out to professors in some instances to ask for that grace or to ask for that empathy, they haven't been met with that. So some of, just briefly, because we'll have a Q&A discussion where I can talk to you all more, but some of the RJ-based and trauma-informed practices that I think can foster connectedness between professors and students do include prioritizing safety. And I think that safety means just a level of inclusion and understanding and that empathy again. So just psychologically, people are much more productive and creative and innovative when they're in happier spaces. When you feel safe and when you feel seen, your brain is just able to decompress itself, interpret more information in a way that allows for you to develop new ideas. However, if you're stuck in that state of trauma, you're still thinking about the old ideas related to that trauma, you're not able to retain anything new. So I think that Emma did an amazing job. She also mentioned like the classroom settings, just possibly not being so hierarchical. I don't know how difficult that may be just based off of how some institutions are already set up, but we can dream pretty big. Trauma-sensitive language, flexibility and accommodations. And I noticed this a lot at my current school, we have an evening program. And though they extend the evening students a bit more grace and flexibility because they understand that they work and have families, I think that fully taking on an integrative model of flexibility and accommodations outside of the formalized, oh, did you have an IEP in high school or undergrad? It's like, okay, I'm not the same learner, human person that I was at that stage. How can I access accommodations differently, and what that might look like? So asking professors to advocate for that as well. Self-care and resources, and making that like a continuing mode of awareness that professors have to be referred to. At my school specifically, there's a larger university associated with it. I've constantly been referred out to like, oh yeah, we have mental health resources here a tiny bit, but you got to walk across campus to that other building and look for this other person. And at law school, and we just saw those suicidal ideation rates, like this is not new to us. We know the numbers around substance abuse. That should be a direct line of resource communication that is just easily accessible. And I think that professors advocating for that would be helpful as well. And then I think we already mentioned some of the like inclusive teaching practices and strategies. Experiential learning for me is one of the biggest ones. So I will pass to Asia now. Thank you all so much. And I want to respect her time. And thank you, Asia, for forgiving me while I get this off the screen, because this was still a challenge 3 years into online learning.
No worries. Thank you. Appreciate your presentation. Hi, everybody. So I'm Asia Reed Foster, and I actually graduated law school in 2020. I was a COVID graduate, and that was a time. But I'm going to talk about something a little bit different, and that is restorative justice kind of approaches and practices in law school honor codes. I apologize in advance because my dogs are right by my side, and at any given moment they can completely go off. And I apologize in advance for that if they are triggered by something outside. So by way of introduction, this kind of idea of looking to kind of revamp and introduce restorative justice practices in honor codes actually came from my experience. So I went to the University of Richmond, and at the University of Richmond, I sat on the grievance committee for our honor council. And one day, I was actually at a party, a friend came up to me, and they had suspected one of their classmates of cheating. And as a member of the grievance committee, which was essentially like the prosecutorial role, I had to see it through. I had to, kind of investigate and kind of follow up and see what was going on, and take the information to the larger grievance committee and explain to them what it was, and that I was going to perform an investigation and then bring my recommendation of whether we should bring a charge or not to the larger group, which we had to vote on whether to charge this student or not. So while I was investigating this allegation of potential academic misconduct, I learned that the professor of the course that was in question was also a professor that I was very, very close to, and she taught the restorative justice class at UR. And we had numerous discussions about the potential infraction and kind of what we thought should happen. Obviously, I had to keep the individual confidential. I couldn't say any names. I couldn't give any kind of identifying information to the professor, but we did say like, hey, it was a writing course. The student was accused of getting help from a librarian on a writing assignment where it was explicitly not allowed in the syllabus. And the student who came to me to kind of bring the allegation forward had seen him in the library talking to a librarian. And so we kind of did this, I did this investigation, and it was one of those things where I had enough information that I thought we as a grievance committee could successfully bring forward a charge. And I was pretty confident that we would be successful in succeeding on the case. However, after talking to the professor, we both decided, we had these conversations, and it just seemed like a very minor charge, and it just seemed like this very like lapse of judgment. And I spoke to the student, and obviously, because for reasons I'll explain, right? Like it's a prosecutorial system, so like the student has no benefit to like admitting to that they did it. So obviously, like he had to kind of remain defensive and not admit that he had actually done anything. But after speaking to this individual, I just wasn't convinced that it was something that should go on the student's like personal record. And when he goes to apply to the bar, it didn't seem like anything that like the dean of students should have to report, which I will also discuss. But I had the evidence. So as a part of our system at UR, I took the evidence, I presented it to the entire grievance committee. I can't remember the number now, but there may have been under 10, but maybe around like 7, 8, 9 of us. And I presented it, and I gave my recommendation that we not bring a charge. And ultimately, we decided not to bring a charge against the student. However, it sat on me that like something needed to be done. It sat on me that I feel not good, but like I feel okay that like we didn't bring a charge against the student and have like his complete academic record tarnished. Like I was okay with that, but it did feel like there needed to be some sort of accountability and ownership for the behaviors, because it was a technical violation of the rules and of the syllabus. So that's kind of how this idea sprouted, was kind of out of these discussions that I had with that professor and kind of me bouncing ideas off of her. Like I said, she was the restorative justice professor. She taught a class in restorative justice. I actually served as like a teacher's aide. I edited the student papers for that class. So I have been around kind of restorative practices for a while. I too am a former K-12 educator. So restorative practice was something that like I learned as I was trying to, build my classroom management styles. And as I was, teaching in certain schools, I was introduced to this idea of restorative justice. So my research, kind of as a caveat, exclusively focused on Virginia law schools. However, my preliminary research in the last month kind of confirms that, this can be extrapolated to all law schools in the United States, all accredited law schools in the United States, because they kind of all operate under the same systems. First and foremost, like honor codes can vary in composition. They can be student run, they can be faculty run, they can be a hybrid. At UR's, ours was completely student run. The prosecutorial section was student run, like the judges, the counsel, the higher counsel was student run. And the student defenders, the student advocates, obviously were students. We had like faculty advisors that we could use, but they could bear like they didn't have a vote on any of our decisions. So honor councils they mirror adversarial criminal justice system. Students are prosecuted, right? Like I served in the prosecutorial role. Some systems include student juries. Ours did not. We did not have a student jury, but like others will. And the accused have the right to counsel. And this too can vary from kind of school to school. Some schools have like a set list of like student advocates that you can use. Some schools, like my school, we had like an elected position where it was like 10 or 12 student advocates, but you also had the ability to choose any student at the school to be your advocate. So it wasn't limited to just those students. And some schools actually allow you to hire licensed attorneys to represent you in these cases. So they mirror the criminal justice system. They're varied from school to school. And the purpose of honor codes kind of serve two main purposes. One is the regulatory function. And so this is where you're enforcing academic behavior. You have oversight, enforcement, and sanctions. Like it just kind of like keeps the gears moving. It's the regulatory function. And arguably, right, like this would contain duties to the academic system and the academic community, right? So the regulation of academic environment is crucial to ensure that every student is committed or is treated fairly. We want to make sure that, and I think through this regulatory function, we ensure that students are equitably treated, right? Like nobody's getting preferential treatment based on, whatever factors may be in play. There's also the educational function of honor codes, and this is to teach students proper academic behavior and also prepare them for potential practice, especially in law school. Our honor codes absolutely mirror the systems that we have in place as practicing attorneys, right? So the legal profession is self-regulating. So a lot of these kind of the grievance committees and these councils that people sit on mirror the exact kind of discipline that you would face if you committed an infraction as a licensed attorney and you were going before the bar grievance committee. It's adversarial. It's, they're presenting evidence and you're defending. So it kind of gets you into the habit as a law student of what to expect as a practicing attorney. So the purpose of kind of the honor code is actually, in my review of the law school honor codes kind of across the state of Virginia, it's explicitly referenced in only a few law schools honor codes, kind of like this tie-in with actual practice. But I would argue that like it's a very big part. Like they are getting students into the idea of, okay, when you're a practicing attorney, and again, we are a self-regulating profession, this is what you have to expect. This is what, this is what will happen to you if you commit misconduct as a licensed attorney. And a big part of that hinges right on sanctions and punishment, right? It's a very punitive system. Like I said, it mirrors the criminal justice system, which is also punitive. So our law school honor codes also mirror kind of the punitive nature of sanctions and punishments and things like that. And again, we see this variation from school to school. Typically, like violations include academic misconduct, which is like lying, cheating, stealing. Law school honor codes can vary in how they describe it. Like some law schools typically like just say like any academic misconduct. Some get into the details and the weeds of like cheating is defined as this, stealing is defined as this. So that can vary. And sanctions for students vary from informal resolution processes to loss of privileges to probation and expulsion. I wrote my piece in kind of like very early, pre-COVID, let's say, pre-COVID 2020. So before kind of the unfortunate murder of George Floyd and kind of like this interest in social justice and building equitable systems. Since then, I found out that, we have made some progress in this space. For example, at the University of Virginia, they had a zero tolerance policy, meaning if you were found guilty of any infraction, you were permanently expelled from the school. So the students had a referendum and they actually got this policy reversed. So like things are moving in the right direction in some ways. But I think that was a very punitive system. And some schools, you might be suspended for a semester. It may depend on the severity of the conduct. In some schools, they're actually violation blind, meaning that they don't look into the severity of the violation at all when determining the sanction. It's just kind of like, if you did X, Y happens, or if you commit a infraction at all, Y happens. We don't care what the infraction was. So more importantly, on top of all of this, right, like law school deans are required to report, at least in Virginia, they're required to report violations to the state bar because law schools have to certify the moral character of their students. And a part of this is like, it doesn't matter kind of what the infraction is. Like if you have a charge, the dean has to report that there's no discretion there. There's nothing. They write it up, they send it off, and it's in your character and fitness when you apply to become a licensed attorney. So this is very high stakes. It can potentially be a barrier to practice. It's, it's the highest that you could do. Like, you get through 3 years of law school, but, you had some small, lapse of judgment and you got undue help on an assignment, and it could potentially be a barrier to you practicing law. So it is incredibly punitive in many cases because, like I said, reporting is violation blind. So I turn to restorative justice as a way to look at how we can change and supplement our honor codes and our honor councils. So going back to kind of the two main purposes from a regulatory function, what we are looking to try to do, right, is manage misconduct and maintain the academic environment in a way that emphasizes equitable treatment. And under kind of restorative justice practices and restorative justice ideas, right, like the responsibility is on the violator to restore trust in the academic environment. Because, as I'm sure like plenty of people have mentioned, that law schools are really weird places that incentivizes really weird behavior because, right, we're graded on a curve, which creates automatic competition, right? Students are automatically walking in the door day one competitive. And, you know, they're very hierarchical places. They're very kind of, you know, they kind of teach independent of kind of like what's going on in the world. You think you get like a lot more discussion of current events in law school, and you really don't. Like you're reading older cases with like older principles of law, and you don't really have like that influx of, okay, well, you know, this is the United States today. How do our laws reflect our values? Those conversations and things like that aren't happening in law school. So it creates a very weird community. But to restorative justice's benefit, right? Like we know, like it's been shown that students who feel like their classmates are given a fair opportunity, a fair shake, right? They may actually be more inclined to report violations. Now, and I think that there's a hesitancy, right? Like if you know that like a student could potentially, you know, have their behavior reported to the bar and potentially lose the ability to get a license, you're less likely to report violations. And as it currently stands, right? As it currently stands, you know, schools do have to manage academic misconduct. Restorative justice would bring a way where if you think that, you know, your friend is going to get a fair shake, if you think that your friend is, you know, not going to be punitively treated, you may be more inclined to report violations because you see it as restoring the community, right? If you're graded on a curve, that means that, you know, academic misconduct is even more heightened because, you know, basically there are spots, and if you are accused of academic misconduct, you could potentially be taking another student's spot. And like I said, it creates very weird incentives and very competitive behavior. But you know, students, I think, will be more likely to engage in the regulatory aspect of honor codes if they believe that, you know, their friends and their fellow students will be treated fairly. And in that case, right, it will become truly self-regulating because we are a self-regulating profession. We will be doing that. I know I'm running on time. I'm going to try to follow this up. Some of the barriers that we have are privacy concerns, right? We can't, as it currently stands, we can't, you know, disclose names. We can't tell anything like that. So it has to be fully voluntary. Like students have to kind of buy into the idea that it needs to be kind of these restorative justice practices implemented, and that if they're on kind of the wrong end of, you know, the stick on that one, then they will fully participate. Obviously, like we can't do anything about the fact that like the schools have the duty to report to the state bar. Looking forward, I think that there are a lot of opportunities here for law schools to really look at their honor codes and really say, okay, what can we build into these systems so that we can truly have an environment where students feel like they're getting the best education that they can, and more importantly, where we can teach restorative justice practices. And I think that that's going to be the bigger thing. I think schools will be very hesitant about teaching, explicitly teaching kind of restorative justice school-wide. But I think that it's a natural fit. And for me, like like I said, it's critical that it's a school-wide approach rather than like a few individuals who have interest in it and kind of, you know, catering to like these small interests. Because it's imperative, I think, that all students have a restorative justice toolbox that they can take with them into practice. And seeing and participating in a restorative justice system lends credibility to the ideology of restorative justice. Like it won't be seen as kind of like this, you know, radical idea of how we should do, you know, think about justice. It would just be a way that we do things. It's important to me that like we build empathetic practitioners of the law. And I think that that starts in law school. And I think that one area that we can look at are definitely law school honor codes. I apologize, Emily, I went over a little bit, but I do want to pass it off to you. Thank you guys, I appreciate it.
No problem at all. Thank you. Asia for laying a really great groundwork of what I'm about to talk next too. So it was really helpful to hear that. I'm gonna share my screen, but I can't share it because I think I don't have access to, if someone can change it so I can add it. And thanks for the folks that are watching. I'm the last panelist, and then I'm excited to hear any questions that y'all might have. Okay, now I'm the co-host, and now I can share it. I don't see the option to share it, but that's okay. My slides aren't that important. So what I'm hoping to use the next 15 minutes is really targeted to the current law students watching this and are interested in bringing a restorative process to your campus, specifically to address student misconduct. So this is actually a great segue. And my background, I'm a current law student. I just transferred from Vermont Law to Brooklyn Law School. And during my time at Vermont Law, I, alongside a lot of students, including some that are in here today, which is really exciting, yes, we were trying to bring restorative processes to be implemented to our institution. So I also have a background in a lot of community organizing. So that's really what I'm hoping to give you all is what next steps look like, pro tips, even though I'm not a professional, like considerations, things to think about as you're trying to bring this to your campus. One out of the many reasons, as we discussed, why RJ is needed and important in law school is also this idea, and Emma mentioned this, to also hold institutions accountable, especially institutions that espouse, social justice and creating lawyers who are going to bring about criminal justice reform. It is imperative that we practice what we preach. And if we are expecting that from our criminal legal system, it's important that we embody that and that we use it in our communities as well. And in this case, our community is our law school. So, pro tip, I was just trying to check. Okay, that's okay. I'm a very visual person, which is why I created slides, but if you're jotting down notes, that should work great too. So my pro tip number one for the law students watching this is get your law student handbook and get really familiar with what your law school does. As Asia talked about, there's a lot of commonalities across law schools on how we approach and address student misconduct. However, every institution is going to have a little bit of discrepancy and nuances that vary. And so it's important that you get really familiar with what your institution does. And as you're reading through it, think about what are intercepts that you could insert RJ in. And so as I was getting familiar, there's very clear 3 categories of what student misconduct is. There's honor code, right? That's academic, as we've talked about. There's the code of conduct, which is non-academic, and that varies from all sorts of things, right? Drug use, vandalism, physical assault, and then there's Title IX, which oftentimes is sexual misconduct. And as I was reading my law school's student handbook, I saw this phrase that said, under code of conduct, the procedures for investigating and resolving complaints under this code include voluntary and formal resolution, mediation, formal process, and formal process. So there's a bunch of options in the table. And I thought, why isn't restorative justice listed as one of them? And we talked about this. One of the biggest barriers for buy-in and hesitation to using RJ to address student misconduct is that these violations are reported to the ABA, as Aisha mentioned. And, I don't have a solution to that, but that's something that comes up a lot as you're trying to get in dialogue with people in your community, both from admin and from students who are hesitant, right, to implement this. So what I did is I read it and then I was like, okay, I'm gonna go talk to administration, talk to the deans. And that can be really intimidating, but that's my pro tip number 2 is don't be afraid to reach out to the deans and administration and start that discussion, because they are the decision makers. They're the ones that get to change what this looks like. So what I did was like, one, can we have this in writing as one of the options in the table as a process to address student misconduct, but also like, what would it look like for us to implement that? And that does involve the community. So like, the stronger your ties are to your community, the more insight and perspective you're going to get, and the more prepared you are to respond to any hesitations or concerns that might arise. And to my surprise, so I talked about this with the deans last year, and I came from a school that, Vermont Law is a smaller school. The deans are actually really approachable and have like an open door policy. I know that might be different in other law schools, but I, along with other students, started those discussions. And to my surprise, from last year to this year, I went back to see if there were any changes that were made. They didn't include RJ in this year's student handbook, but what I did see was a change. They expanded the mediation process, and mediation is not restorative justice. They're very different things. But I'm bringing that because, one, it shows that this is a living document, right? Like, this is malleable. We can change our responses. And then also they talked about non-punitive sanctions, right? Asia mentioned like how detrimental punishment can be for law students. And so here's an opportunity of thinking about what the possible resolutions are, and they list some of them. It's in my slide, but that can involve it says, counseling, an apology, whether that's public or private. And it's not limited to these examples. Promise to cease behavior complained about. Like, there's a bunch of stuff that could just be non-punitive and makes us expand our view of what accountability can be. The other pro tip is, as you're trying to advocate for this, look at other institutions and what they're doing. And Rutgers is one of the institutions, and Rutgers University, including, my cat has the zoomies. Rutgers Law is one of the institutions that uses RJ to address Title IX cases. Now, it's not automatic, but they offer it for the harmed parties, which makes sense, right? Like, a lot of people that have experienced sexual assault and domestic violence many times don't want to report it to the police, and they don't want to go to court. And as we're using this parallel, right, of like this system and like the criminal legal system, it makes sense that there would be students in our community that don't want to go through the traditional process, that want RJ as an option. So Rutgers is doing that, and it's implemented that for a few years now. So yeah, think about what it looks like in other institutions, and that kind of gives you backup of like, hey, we wouldn't be the first one doing this. Okay. The book that I heavily relied on, and you can write this down if you're really interested in like going deeper on this, is The Little Book of Restorative Justice for College and Universities. And that was written by David Karp. And, it's not law school, but it is higher ed. And he does a really good job on laying out what potential frameworks could be. It helped me imagine what would be the alternative to like a traditional disciplinary board. And he lays out 3 frameworks, okay? The first one is restorative justice conferences, restorative justice circles, and restorative justice boards. And I'm gonna just briefly talk about each one. So yeah, that you can figure out like, hey, there's actually, you don't have to reinvent the wheel. Like, someone has like, a lot of people have already thought about this, and hopefully that empowers you to bring these frameworks to your school. So A restorative justice conference, for those who are familiar, it's a facilitated dialogue between, and those involved are the responsible party, in this case, the student that committed the violation, the harmed or affected parties, and then support persons. And ideally, this is trained by a RJ practitioner who's very skilled in facilitating the dialogue. And in this conference, all the stakeholders identify the harm that's caused, and they collectively, as a group, decide what steps the student can take to repair the harm to the extent possible, remain accountable, and rebuild trust with the community. This is a model that directly involves the harm process. So in that sense, we don't want harm parties to feel coerced or forced into participating in it. So that could potentially limit this as an option. And yeah, they're for everyone involved, like, as you're advocating for this, always keeping in the back of your mind that it's RJ in general, can't be coerced and forced. So hopefully the people involved, there's a willingness and there's a voluntariness to participate. The restorative justice circles, for anyone who's participated in the circle process, it's really great for larger numbers of participants. It's also really good for mixed responsibility conflicts, right? Like student fights, or for cases where the responsible party is unknown, but harm has been caused. So the participants are circle keepers, the involved parties, support persons, and other community members. They're great in a lot of scenarios for those who have done a circle process, like every voice gets heard in that. And David Karp does a really good job in kind of going into what the rounds would be. And yeah, so basically the rounds would be, sharing the feelings and perceptions and ideas of what a resolution would look like. And also, just to stress that point of when harm happens and we don't know who did it, a circle is really good to still offer support for the community and strengthen those ties and sharing concerns and creating a plan for the future as well. Last but not least, so I have this slide and then I have a final slide, but last but not least, the restorative justice boards. This is a model that most closely resembles the traditional disciplinary board model, although they operate in totally different values, because the boards are often composed of individuals who are not directly involved in the incident. And so it lacks that emotional immediacy and connection that the other two models provide. And there's pros and cons for that, right? The pros is that a restorative justice board, you can just refer more cases to them. And so it's similar of what Aisha mentioned of other students, faculty, staff being a part of the board. And so it gets more streamlined. It's also good when the harm party doesn't want to participate, but we still want to offer a restorative process for the student. The disadvantage is, of course, that there's not that direct connection to the incident at hand. So this is kind of the clearest of how it would be implemented. But like I said, all of these operate on different values. They're more transparent on their decision-making process. Something that we talked about earlier is that instead of disincentivizing truth-telling, now you're creating space for the student to, for their focus, not to be to, defend allegations, but their focus is now to repair the harm, rebuild trust, take that responsibility. And yeah, and like I said, these are flexible frameworks, but hopefully that gives you all an insight of what this could look like on campus. And the final thing I'm going to finalize with the last considerations and 2 more pro tips. and then I'll pass it on to the Q&A. One consideration that came up in my experience, and something to think about, is who facilitates the RJ process. And ideally, you get someone who's very skilled and tactful on how to do this, has experience with restorative justice, and could be, ideally a third party to avoid bias, someone who's outside of the conflict to facilitate that. But most of the time, a lot of institutions don't have the resources or don't even have the interest to hire people outside of admin and faculty to be responsible for this. So then alternatively, you would train the existing staff on how to do RJ. Something that I thought about when I was preparing for this is, we keep doing this parallel of the criminal legal system, but in our criminal legal system, a lot of court diversion programs are for people who have committed their first time offense. So something to think about, which, I want to create a space for us to imagine what this could be, is like, what if first time violations, automatically it was a restorative process? And then the last consideration is, where do you start, right? If we have those three categories: academic, Title IX, non-academic. It may be a strategy and advantage to focus on one of them and try RJ with one of them. Like Rutgers started with Title IX, VLS, Vermont law, I thought about the code of conduct, right, which is different from the academic and Title IX. Things to think about. My last two pro tips for my presentation is, like I said, get close to your law school community, because implementing RJ to address student misconduct is 100% a paradigm shift. It's going to require buy-in from administration and from students. A lot of students are hesitant about it. So the stronger your ties are to your community, the better you're going to be able to address potential concerns or doubts that arise. Last pro tip is, you can introduce restorative practices amongst student groups. So my 2 years at Vermont Law, I was part of the Student Bar Association, and that is great because we're already connected to all student affinity groups, all student clubs. And so we offered it as a process to build community, which Emma talked about earlier. But also, if student conflicts just arose, for students to know that that was an option, like without even getting administration involved in the first place. And so what that does is, you're exposing more and more students to a restorative process, which hopefully could, increase the voices who are advocating for this and put more pressure on your institution to really take this seriously. And empower students to use this as a tool to build community and address conflict when it arises. So it's kind of like change happens. I always use the puzzle analogy, where it's like all these things have to happen simultaneously to really bring about change. And so that was something that I had noted. That's all that I have. So I'll turn it to Leah, and if there's any questions.
Yeah, thank you so much, Emily. So we are going to go ahead and shift to our Q&A portion. So send any questions that you have in the chat. You can ask questions of specific panelists, or if you have questions for all of the panelists, go ahead and throw those in the chat. And I'm going to go ahead and spotlight all of our panelists again here. I think that's everyone. Emma had to leave, so we just have the three panelists here. So I'll go ahead and kick us off again. I'm not seeing any questions in the chat yet, but go ahead and send those in. This is a question for all three of you. Do you have any recommendations for engaging in this sort of movement work, in this sort of institutional culture shift, when students' time at law schools is so short, only 3 years to 5 years, and institutional change is so slow?
Oh, my mic is on, so I'll actually jump in. I think we touched on this. I think the best way to understand RJ is when you participate and you see it firsthand. I think you should mention that, and I felt that very much that, and you're right, it's hard to get involved in this, but I think it really helps to experience it first person. And so because that way you can also see like ways that you can implement it. So this isn't really answering your question at all, but like I would like volunteer in Vermont. You have community justice centers outside, and it was once a week, but it always kept me in touch of what an RJ process is in practice rather than just in theory. And I think that just helped me have the language and like the understanding of like what it can be in this community. I'll pass it on to Kaylin.
Yeah, I think for me, kind of speaking anecdotally, the biggest thing was, like I said, I had this professor that taught restorative justice. So, two, she served as a mentor for me in multiple ways. And that, one, like she was constantly giving me things to read. So I was constantly reading and learning in that aspect. And she was very institutionally valuable to the law school. So she was a great ally to have when I was constantly in the dean's office fighting about something. So I mean, so the dean's office didn't love me. They didn't like me because I was always, kind of in there, talking like, hey, can we do this? Hey, what about that? Like, hey, your approach about this is like really not student focused, student centered, like, and it's just wrong. She was a great ally for me. So I think it's about like finding those allies within the faculty and within the administration. You might have somebody in the administration who is kind of sympathetic and knowledgeable about these types of things. So I think just see kind of those relationships. Like I said, me and this professor are still very close to this day. And she's just a great person and like just a very good like moral compass to the point where it's just like if I was having issues, it's like, okay, like I'm not sure what to do about this situation. Kind of outside of that, like I found her to be like, okay, like this is the way that I should think about it. This is how I should be doing it going forward. She counseled me. So I work for a big law firm. Like she kind of counseled me when I was like having very real trepidations about going into big law. So definitely find those people and they will help you. And even when you leave, like I'm starting to see now some of the things that like I was arguing about when I was a student, like now I'm 3 years out, like now I'm starting to see the fruits of that. And it's about building those relationships.
Yeah, I definitely agree. Just to that point, to build on it a bit. One, that's exactly what I was going to say is like find an ally at the school that is either in some administrative capacity or faculty, but also find your niche because I think someone earlier mentioned like they're not necessarily an incrementalist, and I didn't think so either. Like I was always very much so destroy it from the inside, rebuild it. But when you are dealing with some of these just everyday stressors, I'll call them, of law school, you're just trying to figure out when the midterm schedule is going to drop, if you're going to shower today, what's the quickest thing to grab out the fridge. And when you do find your niche, like last year, I was on the Student Health and Wellness Committee. And back when I was at VLS, because I also transferred, when I was at VLS, I was on the Mental Health Committee. And I hadn't noticed until one of my professors like put it all on the table and was like, okay, this is your thing. Like, you're very passionate about how mental health shows up. And I was just like, oh, I thought it was just because, I'm generally depressed and I need to find other people to talk to. But when you find those community circles and pockets of people and they kind of trickle into their own separate niches as well, I think that it can be more impactful and just have that ripple effect, like Aja said, long after you're gone. So
Yeah, thank you for those thoughts. We have a question from the chat. Which university department would be best to start a restorative justice program under?
I mean, like the departments like career services or this other thing. Is that what Linnea?
It's Linnea. Thank you so
Linnea.
much. Yeah. I'm starting to become affiliated with a university down here outside of Richmond, and they don't have anything like this. And I'm just trying to figure out where to try to fit it in under like student services. Like if I'm going to get in there and start lobbying for these kids and the students to get this in place, I'm just not even sure where to start.
I noticed one of the things that I noticed being out here or after I transferred, I'm at North Carolina Central now. I know it's been like, I haven't mentioned it directly, but one of the things that I noticed was their clinic base is huge. So law school specifically, going to whatever clinics that you think may be most aligned. Here, the civil litigation clinic is actually run by Scott Holmes, who's like a restorative justice pioneer. And he implements it that way, but also even at a not necessarily more micro level, but the organizations, like I'm on the Civil Rights Society, and we do things that partner with the community specifically and have community members like RJ Durham come to the school and host panels and let people know like we just exist. So I think that might be one of the steps.
Thank you, Ms. Taylor. That's very helpful. Thank you.
We'll do one more question and then we'll take a break before we move to the breakout rooms. What are some good touch points for community buy-in and input when you are first developing an RJ program on campus? And that again is open to everybody.
I think just building kind of community in general is really important. So here in Charlotte, I'm involved in a number of like just social justice kind of activities and things like that. And I think one of the first things that we always try to do is just kind of like know who you're in community with. Because when you introduce restorative justice, depending on the background of that individual, they may have a recoil and they may have a feeling about it. And so what you want to do is have that kind of relationship with people where you can have conversations that may be hard, but they're going to hear you out because you've already built kind of like that rapport with them. I think that that is super important. And I think to specifically answer your question a little bit more, I mean, I think that you have to, so we do something called breadcrumbing, and I think that you have to, like, one thing I've learned in like social justice work is that like you kind of have to breadcrumb for people, especially people who are not not directly involved or like haven't really dealt with the material before. Like you kind of have to like drop little nuggets that they can ingest. And then like you kind of move on to other things because like, you know, especially like within the honor code space, if you go in saying, we shouldn't suspend any students, they're not going to be very amenable to that. Like their ears are immediately going to shut. And I understand why, right? So I think it's about kind of building relationships first and then like, hey, well, what if we had like before we bring any charges, what if we had a conference with the accused and had them, kind of completely confidential and kind of have them kind of talk through things, outside of, kind of like an alternative solution, something like that. Like you just want to give people, I think, a little bit at a time that they can ingest.
Yeah, I echo that. I'd also add to that there's a lot of misconceptions about what restorative justice even is. So I think another thing in thinking about the breadcrumbs is like Taylor mentioned this too, like bringing people, like whether it's like a workshop or a lecture, like this educational part of it, so people also understand what it is. That could be also a potential way to just expose people to these topics.
All right. Thank you all so much. Thanks to our panelists for for your presentations. I am sure I speak for everyone when I say that you have given us all a lot to think about and reflect on, and I'm excited for the conversations that we're going to have in the breakout rooms. We're going to take a short 10-minute break before we go to the breakout rooms. So come back at the 15-minute mark and we'll go into breakout rooms. And if you could just turn off your video and mute yourself rather than leaving the Zoom meeting, that way we can easily start putting people into breakout rooms. So thanks again for our panelists, and we will see you all back here at the 15-minute mark. Our last panel of the day, I'm so excited about. We have a career panel with three really incredible panelists who are going to share their perspectives with us. We have Kristen Edwards from the Metropolitan Public Defender in Portland, Oregon, Hannah Rose Grodel from the Tulane Law Clinic Women's Prison Project, and Erica Washington from Impact Justice. So, Demaite, if you don't mind spotlighting our three panelists, we will have some, hopefully time permitting, opportunity for questions at the end. So you can go ahead and send those in the chat as we go. But I'm going to go ahead and kick us off with our first question, and we'll start with Tristan. If you could share with us a little bit about your journey through law school and how you got involved in restorative justice work in your current position.
Great. Well, it's really such a pleasure to be here. Thank you all for having me. So my name is Tristan. I graduated from law school in 2017. I went to NYU, and I got some exposure to the concept of restorative justice before going into law school. I think probably the first time I experienced being around kind of restorative practices was the year after I graduated. I lived in Rwanda for a year, and I wasn't there to do restorative work, but it was incredible to live in a space that the culture had so much been shaped by a national implementation of what processes very akin to restorative justice to recover from the genocide. And so it was really interesting to just kind of see how that played out, even just in people's day-to-day interactions with each other and their willingness to kind of build bridges. And then before I ended up even applying to law school, I was in Brooklyn, and I heard a talk by Danielle Sered from Common Justice, and that the pieces just really connected there, and I was fascinated. I ended up going to law school with the interest of being a public defender. I really didn't know how to break into the restorative justice space, and I knew that I was passionate about racial justice, about trying to serve, our most vulnerable communities against systems of oppression. And so I really focused on public defense when I was in law school. And I remember trying to get some exposure to restorative justice. I started a group that was framed around alternatives to prosecution, but it felt a little bit impenetrable. And so then I went into being a public defender, and I really, I think what I decided was, I'm going to spend, the next however many years just focusing on being a really good public defender and doing this really valuable work. And then, as I learn more about the community, as I learn more about their needs, about what restorative justice looks like in Oregon, I can figure out a way to move into that space. But I had no clear plan at all. And I really think, it has turned out in a way that I would never have expected, and much sooner than I expected. But I think that spending those 3 to 4 years of really just focusing on learning the legal system, understanding what it means to be a criminal defense attorney and the needs of the population that public defenders serve was really critically important for me when I started stepping into more restorative spaces. And there was about a year period of overlap when I was working on restorative justice issues and carrying a full major felony caseload, which was very challenging for me. And I guess I mentioned that just to say that, my pathway into the work was not easy. It wasn't simple. It wasn't about finding the right job that I could apply to. It was, kind of something more along the lines of movement lawyering, I guess, but trying to do it while also carrying, and so the opportunities opened up for me actually around when COVID hit. After the first month of COVID, where, you know, all the public defenders were in a scramble, wondering if our clients were going to die in the jail, trying to get as many people released as possible. Things kind of slowed down because the court system didn't know what to do. And it gave me an opportunity to just learn. I just set up meetings with folks who were doing restorative work in Oregon, and really took it as an opportunity to just soak in a lot of that knowledge. And then I had the opportunity to join, as folks probably know, in Portland and in the entire United States. The summer of 2020 was very politically charged. There was a lot of protests around the murder of George Floyd, and in Oregon, it sparked a lot of conversations. And it led the governor to create a racial justice council, where she was trying to empower leaders of color to create a more race equitable Oregon. And so I ended up getting appointed to one of the committees of that council. And in partnership with Erica, I came up with the idea to create a restorative justice grant program. So a dedicated grant program to fund restorative justice as an alternative to prosecution. Now, I can talk about this later, but one thing I've learned is that once you have one amazing progressive win, you spend a lot of time just trying to hang on to that win. And so we were able to establish the grant program, and I feel like I'm going to spend my entire career just trying to maintain the grant program. But the good news was that it was able to fund 8 different programs in 7 different counties across the state. And so and part of that grant funding also went to create my position at MPD. And so now my position is no longer, you know, major felony attorney, but I'm now the lead attorney for restorative justice at Metropolitan Public Defender. I'm going to close really quickly here, but one thing I'll say is that it's just been one of the most incredible things has been working in an office that genuinely supports restorative justice and really believes in the mission that I'm trying to pursue. And that has been so critically helpful. You know, my position is primarily grant funded, and that always creates instability. And working in an office where I feel supported, where I know that I'm going to have folks in leadership who are going to be looking out for me and helping me try to continue pursuing this, has also been a really big piece of me being able to even do the work that I'm doing around trying to promote the use of restorative justice as an alternative to prosecution in the state of Oregon.
Thank you so much, Tristan. I'm going to pass it to Hannah next. Same question, how your journey through law school and then how you got involved in restorative justice work.
Sure. Yeah. Hi. Thanks for having me. I graduated from Tulane Law School in New Orleans in 2015. I too wanted to really be a public defender. That was what I was preparing for. There was a hiring freeze and all this political stuff going on. So I couldn't find a way into doing public defense. I ended up, but I was a third-year law student in the criminal justice clinic practicing as a student attorney. Ended up getting hired at legal services and doing domestic violence advocacy in civil court for about 6 years. Got really burnt out. Stepped back, was able to kind of to take a break and reassess, and then ended up getting offered a position, which is my position currently, at the Tulane Law Clinic, working for a new program called the Women's Prison Project. So it's a collaborative clinic between the domestic violence clinic and the criminal justice clinic. We represent, our primary work is providing direct representation to women who are incarcerated and criminalized for reasons relating to their experience of abuse. So most of our clients are incarcerated, are serving life without parole sentences for killing an abusive partner in self-defense. So that's like the majority of the work that our program does. I was hired as a fellow on a specific project to work with sometimes they're called jailhouse lawyers. In Louisiana, we call them counsel substitutes. So incarcerated legal experts. So women who are working from inside the women's prison in Louisiana, doing legal advocacy for themselves and hundreds of other women from, behind prison walls. And really, for me, in that year that I was stepping back, unlike you, when you were speaking earlier, Tristan, about how you had kind of already had a background in restorative justice, I feel like coming into the game late. And so it wasn't until that year I started reading everything, going to trainings. I met my collaborator, who's actually on the call right now, Nick Moore, who had been a restorative transformative practitioner, educator, mediator for a really long time. And so when I came into the fellowship position, I had that really fresh in my mind, that if I was going to be going inside the women's prison, we were collaboratively building materials, like practice manuals, resources to support the legal work that they were doing from inside prison, that I knew that in order for it to be sustainable and in order for the things that we were producing to produce quality materials, we had to have quality relationships. So it was not envisioned as a restorative justice practice position, but it was something that we realized we needed to really build quality relationships through community building inside the prison law library to be able to effectively collaborate and work together. So that's kind of the general background of where I'm at now. And it's gone in other directions, and we can talk about that if there's time, but that's just the context.
Yeah, thank you so much. And finally, Erica, same question to you.
Yeah, awesome. And again, thank you for inviting me to be here. I'm excited to meet you, Hannah, and hopefully we'll get a chance to meet some of the students on the line. I also went to NYU, so graduated in 2017, just like Tristan. I always think of like going to NYU as a decision I made fully out of my sense of the relationships I would get to build with the other students going to NYU, and not really having to feel like I was swimming upstream all the time. And just, it felt like it was attracting. I was also a Root scholar, so I knew I was going to be kind of held in a space that some law schools really don't have. Because honestly, what I realize in reflection is I went to law school mostly out of an interest in the question, what is justice? ? Like, what even is justice? Which like is not the animating question for a legal education. So, I learned quickly that maybe I was not in the right space, but at least I was surrounded by people who I felt were animated by similar questions, even if we weren't in a space that like created, the opportunity to explore in the ways that I had hoped. So I ended up, similar to folks on the call, really focusing on criminal defense, did our juvenile defense clinic. I also did an equal justice initiative clinic. So that was flying back and forth between New York and Alabama, working on capital cases down in Alabama with the equal justice initiative, which has also been such a teacher to me in the restorative justice field, mostly around like truth and reconciliation and the work that Brian Stevenson is really doing to really like uplift the truth of our country. And so anyways, I think of that work and conversations we had in those spaces as restorative in nature, but certainly I didn't even learn about restorative justice until I graduated. And so doing like criminal defense work, doing capital defense work, I ended up graduating and going to the Center for Death Penalty Litigation, which is an organization located in Durham, North Carolina, that really focuses on representing the folks currently on North Carolina's death row, folks charged with capital murder, and had a few federal cases outside of North Carolina. And so my criminal litigation defense work was really with CDPL, and I did that for about 3 years. And again, I mean, throughout the clinic work, throughout working at CDPL, all of it felt like deeply misaligned with my body, my mind, my soul around how do we actually talk about harm, right? And also, how do we talk about the most intimate things of our lives together. So how do we talk about harm and death and dignity and accountability and race, and doing it in this container of a courthouse? Just like, I mean, yeah, it's like if I can feel that disgust in my body. And I always think of this quote by Glennon Doyle where she says, whatever insults your soul is always a matter of life and death. And it just insulted my soul. And so luckily, yeah, and the other thing that I always think about is like, I was in a car accident at the end of last year, and it was kind of a bad one. And like, no one looked at each other, no one said anything to each other. Like, the most human moments we have are scaffolded by a legal system that does not allow for humanness. And so it just was like, yeah, just kind of observing that throughout my early career led me to really start reaching out to community members in North Carolina who were interested in restorative justice. A colleague of mine introduced me to folks involved in what's right now called Restorative Justice Durham. And so it's an organization, it's a community-based organization in Durham, North Carolina. They trained me. It was kind of similarly, something that I've been thinking recently is like, our law schools teach a certain justice framework. And so restorative justice is a different justice framework. Transformative justice is a different justice framework. Like indigenous justice and peacemaking is a different justice framework, or truth and reconciliation. Like, we are almost like brainwashed to feel like there is this one framework for justice or criminal justice, and we don't. So you're already like operating like not as pulled back when we're talking about how we reach a just outcome. So these folks were really talking about like, what are different justice frameworks? And restorative justice is the one that they really felt in alignment with. And so ultimately they trained me. I started facilitating with them. I was continued to doing the capital defense work as well. I'm going to wrap this up. Okay, so I also, though, through working on their coordinating council and really helping to build up that organization, used a lot of the materials that the current organization I work for, Impact Justice, makes publicly available. So we, create materials. We also partner with communities across the country that are looking to build restorative justice diversion programs. That I just came from a meeting with Tristan about the program in Portland, Oregon. So we work across the country, helping people move from like, I have this dream of a different justice framework operating in my community than the bullshit that I've been sold. And how do you move from kind of dream to demonstration and then study it and try to publish on it? So that's what I'm doing now. But I tried to find my own money. I'll get into that. Like, it's a lot of finding your own money to do the things you want to do. But passing back to you, Leah.
Yeah, thank you so much. The next question I have for the three of you, and we'll just go in the same order. So starting with Tristan again, is, if at all, how has having a JD benefited your restorative justice work?
Yeah, that's a great question. There have definitely been times when I've questioned whether becoming a lawyer was the best way to engage in this field. And I think it really depends on what you want to be doing. And I think that, if I had been a little bit more knowledgeable about what it meant to work in restorative justice, maybe, I don't know that I would have made a different choice, but I maybe would have been more thoughtful about the choice that I was making. Because the reality is, to be a practitioner of restorative justice, not only do you not need to be a lawyer, but it's not even necessarily like beneficial to being a lawyer to actually, facilitate restorative processes, be a restorative justice facilitator. The director of our restorative justice program here is not a lawyer, that he is a background in mediation and practicing restorative justice. And actually being an attorney in this space has been, I think that there were some growing pains for me in the beginning, realizing that my role is not to be a practitioner. It's not to be a facilitator. And it's something that I would love to get exposure to, to actually see the power and magic of restorative justice in action. That's not my role. My role is to be kind of an attorney advocate for the general movement. A lot of my work has led me kind of into the statewide advocacy and legislative spaces. But I also get the opportunity to work on the programmatic level. And so, partnering with Impact Justice has been awesome in terms of developing the program here in Multnomah County. I serve as the defense representative for that program, which gives me a lot of authority in terms of, engaging with other system partners around how we shape this program, and having the knowledge of the ins and outs of the criminal legal system has been really critical to that. And then I also work as kind of a consultant on other programs across Oregon, and work as an organizer to kind of get all of these programs together to have discussions around how we're going to do targeted advocacy, how we're going to do public education around restorative justice. And so even though my law degree has kind of in some ways cut me off from being able to, be in those restorative spaces, it puts me in partnership with so many people across the state who are doing this work. And I guess in terms of being a lawyer and how it's helpful, well, I have definitely noticed that when showing up in policy spaces, whether it's my committee through the governor's office, or it's testifying in front of the Judiciary Committee in the state legislature, or even just showing up to a community-based organization to try and help facilitate, community readiness assessments, having a JD behind your name helps. It helps just with your, people taking you seriously, with your own legitimacy. And it's interesting because in a lot of ways, my, at least the brain that I developed doing criminal cases, oral advocacy in the courtroom and kind of motions writing doesn't apply to the work that I am doing now. But certainly having a good understanding of that has been critical for all of my work, but especially legislative and program work. This year, one of the big wins that we had with the Restorative Justice Coalition of Oregon, which I'm an active member of, I chair their what is effectively their legislative committee, but we call it the Community Action and Advocacy Committee because we want to really expand beyond the legislature. It is not, despite all the talk that I've said, like, it is not my passion to be working in the legislature. It becomes necessary at times, specifically for our funding, but there are in a lot of ways, the legislature is not necessary for restorative justice outside of that. Though this session we did work on getting confidentiality protections in the state of Oregon for restorative justice programs, and being a lawyer was incredibly helpful in navigating that process, in knowing what was going to be important for the bill language, and knowing what kind of bill language actually could be misinterpreted down the road. And so I have a little bit of a tortured history with a relationship with my JD, but ultimately I think it's put me in a space where I can be most effective as a leader and an organizer, and certainly lends a lot of legitimacy in those spaces.
Thank you so much, Kristen. Hannah, same question.
Yeah, thanks for saying all that. I definitely felt that a lot of that resonated with me. Yeah, I think that having a JD and going to law school gave me access to the people I wanted to work with and the places I wanted to do that work. So I had always wanted to work directly with incarcerated women, and I would not be inside the women's prison every other week for the amount of time that I am, with the kind of freedom and autonomy and agency, if I did not have a JD, if I wasn't a lawyer, if I didn't have the relationships that I made with the law school at Tulane. So that's huge, even though what I'm doing in there isn't, kind of like what Tristan was saying, it's not like legal practice, strictly speaking. That credential and that background definitely opened the doors. And then I agree also with what Tristan was saying about we're community building inside the law library and the women's prison, but being a lawyer and having a JD gives me legitimacy with the people that I'm working with. It enables them to trust me, to know that I have that. So it's like the access goes both ways. They know that I have the access to the law school, that I have the access to those resources and the kind of like institutional privilege that comes with. enables me to build relationships effectively inside. And the fact that I'm having the relationship to the law school and that I have a legal background in education enables me to get in the doors. So it's like going both ways. And I think in my situation, it's a little bit different because I am working with legal experts, but so it's a little bit more relevant. But yeah, I would say that it's mostly about the access and the relationships, people I wanted to work with.
Thank you, Hannah. Erica, same question to you.
Yeah. And I wish I didn't have the same answer. Yeah, honestly, I just really echo what was said. Yeah, I really, again, I feel like, I don't know, is EJW still funding like law students to do projects? I just, unfortunately, there's how did my JD help me? Access is a big one. You know, a lot of my role at Impact Justice is to help, like, work with experts on the ground to identify off-ramps from the criminal legal system. So where are the doors? Where are the ways out of this system? And then into community-based restorative justice programs. And so, you know, certain people get into the courthouse, certain people are in the conversation, are in, you know, to understand how this machine is operating. And if your goal is to find ways to deconstruct that machine, understanding how it's operating is pretty critical. And so, yeah, so honestly, I have to thank my time working as a kind of more traditional defense attorney, and really thank, you know, the folks I work with who are actually in those systems that I'm partnered with, because it is through those conversations that we really identify and push for that off-ramp to be as early as possible, which I will name, you know, sometimes ideally those are pre-charge off-ramps. So just kind of a warning, I have met a lot of folks, especially public defenders, who don't really know much about what happens prior to charges occurring. So there is also a way that, like, everyone kind of has their own lens of the system, but like the full understanding of that machine is, you know, it can be quite hard, and I think intentionally hard. It's not a transparent thing. Every county operates differently. So kind of wide scale criminal justice reform efforts are very hard to make happen because it's a local game so often, and understanding how the machine works here in this county is so important. And lawyers are the ones who I have the best chance of getting an understanding of that machine from. And of course, it's one of the reasons why I was hired at Impact Justice. I wish I had paid more attention in contracts. You know, we use memorandums of understanding, which I always talk to the community-based organizations about, like, in a way, it's just kind of clarifying all of the relationships involved in making this thing happen, and people making sure, like, we're on the same page and signing. And an MOU is just going to outline, like, you know, confidentiality protections for these programs, the referral process for these programs sometimes will include the case types that are going to be sent to these programs. And, you know, so anyways, it helps to kind of not feel fear around the creation of documents like that, and also to be able to bring kind of a relational orientation towards something like that. And then let me see if there's anything else I wanted to say. Yeah, I mean, obviously you learn critical thinking skills, you hone your analytical skills, I ideally hone advocacy skills, and you're going to be advocating like hell for these opportunities to actually happen. And so, yeah, and so I do want to name that. And I think lastly, I'll just say, kind of lift up what Tristan named. Like, I think we get, you know, we kind of conceive of our role as, like, learn how to make law, not just case law, right? Like, how actually, like what Tristan just spoke about in terms of the legislature, like, how are laws made? How, you know, it is because of laws on the books that we can't divert cases as early as we want. It's because of laws that we have to work with these low-level cases that studies show aren't even as effective with restorative processes. It's because of laws that these processes aren't protected. You know, now in Oregon they are, and that's part because of, you know, a lot of work that Tristan did. And so ultimately, right, like, there are a lot of laws on the books right now that either need to go or new laws need to be added. We are in a bit of a protect stuff, like hunker down and protect stuff mode, which is really unfortunate to say. But we just passed a law in California that makes it so survivors of harm, victims, people harmed, have a right to be told of restorative justice options in their community. So legal system partners have to say, you have this option in your community. And so learn how to create laws. And I think law school tends to offer some opportunity to engage around that learning.
Yeah, thank you so much for those insights and for your candor, all three of you. Sort of following the same thread, what advice would you give to JD students who are interested in working in the restorative justice field? And we'll start with Tristan again.
Well, my advice would be to become a public defender. Speaking from a totally non-biased position that has nothing to do with my personal experience. But, you know, I'm really curious to hear how Hannah and Eric have to answer this question, because of course, you know, my answer is very much shaped by the experience that I have had. And I come at it from a specific lens, and that is, you know, a lens that is really in alignment with the values of public defense. But I've learned so much from being a public defender. One, I have just been put in just beautiful relationships with people that I otherwise would never have had exposure to. And they are the people that are suffering from all of the social justice issues that plague our state and our country. And so just getting really close exposure to the people who are directly impacted by our systems has been incredible work. It has also exposed me to working with a lot of survivors of harm. And that includes people who are listed as victims on my cases. I develop good relationships with a lot of named victims. It becomes necessary, and oftentimes, especially when I was in misdemeanors and minor felonies, I was having a higher level of communication with victims than even the prosecutor was. And a lot of that, frankly, has to do with frankly, that a lot of times victims get neglected by the system, even though their name is used frequently to prop it up. Other survivors of harm that I work with are my clients. I would say the vast majority, if not over 95% of my clients have been victims of severe harm. And then we wonder why they end up within the criminal legal system. And there's no mechanism, it seems, for really addressing that trauma. Even though we talk about it a lot within the criminal system, we typically talk about it in a way that's like, please reduce the number of prison months. I'm not even sure it really has that impact, but it really feels just, we are not creating adequate solutions. If the answer to my client suffered serious sexual abuse when he was a child and is still dealing with unaddressed trauma is, okay, we'll shave 6 months off their prison sentence. And I think another thing that has been really profound about working as a public defender is that it has provided me with a really good lens to see just the illogic of the system. Like, the more I work in restorative spaces, the more I learn about restorative justice, the more it just feels like common sense. It is just so much more closely aligned with the way that we resolve conflict and harm in our own personal lives than it is you know, than the criminal legal system, which really distances people from each other. Both the harmed party and the responsible party, immense barriers are put between those people in terms of understanding the other person. And then, of course, the responsible party from the community as well, because the reaction is to isolate that person, to keep them out of society, that when they are allowed to re-enter society, to put immense burdens on them, to make it even more difficult, and then to wonder why they end back up in the criminal legal system. And I guess the last thing that I'll say is that I think that working as a public defender has also allowed me a really, really kind of unique perspective on what accountability means. One future project of mine, something that I'm hoping to hone better and to kind of spread more public education around, is what we mean by accountability. Because I've especially when I've been in kind of law enforcement spaces, I've heard things like, oh, well, we're worried about restorative justice because there's no accountability. And it's so funny to me because you think about the difference between sitting down after someone has worked with you extensively to prepare you for that conversation and sitting across from someone that you have harmed and having to look them in the eye and hear about the impacts of that harm and have to answer questions about why that harm occurred, and then really engage actively in how you're going to repair that harm to that person that you are now, repairing your relationship with, versus our criminal system where, you speak with a police officer, and if, the first thing that police officer tells you is that anything that you say will be held against you. And maybe then they convince you to believe the lie that if you come clean early, then things are going to be better for you down the line. That is absolutely not true. When it comes to negotiating deals on cases, when it comes to trying cases, the most important thing is whether the prosecutor can prove their case. That is the number one important thing, no matter what a DA might be saying is important to them. It really just comes down to that. And if your client has confessed, well, then they've got their case. And so really coming clean early, taking accountability early, only hurts people. Then they make it to their arraignment where an attorney, oftentimes me, tells them, don't talk to anybody about this. Don't talk to your closest family members to try and process what you've done or come to terms with it. Don't talk to your closest friends. Speak to no one. Oh, and also you're going to be entering a plea of not guilty, whether or not you think that that makes sense or is consistent with what happened. And then the only person they can speak to throughout this entire process is a defense attorney. And a defense attorney's role is not to encourage someone to come to a space of accountability and process their remorse and understand the impacts of the harm. It is to try and, in many ways, to try and manipulate the facts if the harm actually did occur, and trying to figure out a way to cast a narrative that diminishes the harm of the harmed party, that diminishes the culpability of my client, sometimes just outright denying that culpability. And that is what the legal system encourages. That is our system. And so, where is accountability in that? And so I think that just having that depth of understanding through the work of public defense has been, frankly, more helpful to me in the restorative justice space than in the public defense space. I kind of sometimes joke that public defense makes me better at advocating for restorative justice, and learning about restorative justice makes me worse at being a public defender, because I just want so much more from than our system has to offer. But that would be my piece of advice. I think that public defense work and restorative justice work dovetail so well together. And the one last thing I'll say is that relationships really form the core of restorative justice. And I always love to say that, public defenders, in my opinion, are experts in relationship building, because we do not choose our clients and they do not choose us. And it is our task to build trust with someone who has been so wronged by the system, where there's it's just the worst breeding ground, frankly, for being able to form trust. And that is our task. And it is a really beautiful thing to when it happens, and it happens all the time. So that's my final answer.
That's awesome.
Thank you so much, Tristan. Yeah, Hannah, same question.
Thanks. Yeah. My advice would be that, restorative justice practices, trauma responsive advocacy can be applied to your job in the legal field, no matter what position you have and no matter where you're working, though I love public defenders and I agree, everybody go be a public defender. And if that's not an option for you, which it wasn't for me, that's, you might not be practicing in a strictly restorative justice program, but as Tristan mentioned, the importance of building relationship, the importance of building trust exists in every context, no matter where you find yourself. if that's representing clients, if that's communicating with family members, if that's negotiating with an opposing party, if that's building a relationship with a judge. It's, trust is necessary to be an effective advocate, and people don't, you have to have vulnerability, you have to have honesty, and that's not going to happen if trust isn't established. So I would say, like, yeah, that's my advice, is kind of, no matter where you find yourself, that there are ways to incorporate these practices and these principles, and remembering that, people are the experts of their own needs. And I think a lot of times as lawyers, that's what we're doing. We're advocating, and supporting them in getting those needs met. And I think to really be able to do that, you're going to have to build relationships, and to build relationships, that's going to take time. And public defenders, people in legal services who have huge caseloads and are way under resourced, like, you're going to have to fight for that time. And I know that that's something I've had to really, that's something I've experienced a lot. It's like a lot of grant funded programming. They're talking about outcomes, case numbers, it's these metrics and these measurements that are not, you can't measure the quality of a relationship. And I hear a lot, like, it's a waste of time. We don't have time. We don't have time. And this thing that we keep coming back to, about you're buying back time later by building that relationship first. And I think that just being protective of that time and remembering, like, it's integral to your advocacy no matter where you find yourself.
Thank you so much, Hannah. Erica, same question to you.
Yeah, two great answers. I think, I'll just say, in terms of advice, I think honestly, I would start with thinking, what else do I need to learn? What did I not learn here in law school? Also, what do I need to unlearn? And who can help me with both the learning and the unlearning? I know my colleagues have had to do a lot of teaching for me. I did not come in, law school did not provide a lot of the learning that I ultimately have needed. No one's surprised by that. So I mean, I would say that. I would say, really dive into, I know you all have already really explored restorative justice, but also transformative justice and community accountability and indigenous justice frameworks and peacemaking. And like I said, truth and reconciliation frameworks. So, just like additional learning would be a piece of advice. I would say that, where my mind goes out of, like, kind of my dream mind, every Friday, my team, we have this thing called Dream Fridays, and we dream about justice. And it's like, it's interesting because we always have, like, the relationship between, like, joy and justice, or honestly, like, the erotic and justice, or psychedelics and justice. I'm kind of calling us out right now, but yeah, trying to just kind of break out of the, like, way, the frameworks that we've existed in when we think about justice in this country. But one of those frameworks is obviously, like, a very Euro-American individualistic ideology that is codified into our laws, into our laws, right? Like, that's not just the criminal legal system, that's property law, that's education law, that's family law, labor law, health law, environmental law. Like, everywhere we look, we've codified individualism, isolation, disconnection, and everything that is the antithesis of the principles of restorative justice, right? I mean, Tristan spoke about, like, her clients, you sit there and then the survivor comes in that door, never shall that two meet, don't talk to anyone, don't talk to your family members. Like, Father Boyle, who started Homeboy Industries, he always says, like, the fear is that people will run out of relationships. We know relationships add 15 years onto your life, like trusting relationships. So ultimately, like, what are all of the laws that exist in all of these areas that are antithetical to our ability to build strong relationships, maintain relationships, repair relationships? I talked about the car accident I was in. So part of me wants, I guess, I don't know if this is advice, but, like, wherever you end up, the principles of restorative justice, like, are not showing up in the frameworks that you're operating within. And so figure out where we need to shift wherever you're practicing law, you know, and yeah, and see what you can do to shift it. Yeah, that's, I think I'll go with that.
Yeah, thank you, all three of you, for that advice. It's so helpful. We're almost out of time, actually. It has gone so quickly. So I just want to open it up to any closing thoughts that you have to share.
I feel like right when you said that, every thought that I had just kind of drained out of my head. So I'm gonna support somebody else jumping in if they've got something top of mind while I think of something really brilliant and profound to say.
I don't know about really brilliant and profound, but I can share something that I'm thinking about, which is that since learning more about restorative justice practices, I can see in so many contexts and situations where these like really problematic, exploitative, hierarchical power dynamics exist between lawyers and clients. That exists between professors and students, that typically traditionally exists between, you know, where I work, like incarcerated legal experts and legal experts who are working on the outside. And I think what is very exciting to me about restorative justice practices is kind of what Erica was speaking to about dismantling the ways that we've been taught and conditioned to have relationships. And that's exciting to shift the culture around that, about how we're learning, about how we're practicing, about how we're advocating, and about how we're building relationships, like in a, yeah, we're practicing in a relational way and not a transactional way. And I think that this like enriches our movements, it enriches our communities, it enriches our ability to like learn with each other and build power. So that's just kind of something that's exciting me on a Friday afternoon.
I just saw that somebody put a question in the chat, and I feel like my answer is going to be a good segue into whatever Erica has to say, because really Erica has been one of the really most important mentors that I've had in this work. She entered the restorative justice field before I did, working at Impact Justice. And ever since I've stepped into this work, which is in large part due to her helping educate me, helping understand even just what restorative justice across the country looks like and what the possibilities are, is somebody that I continue to return to for a lot of wisdom, and all of the folks that she works with at Impact Justice. It's a really incredible organization, and I would highly recommend, if anybody has an opportunity to go to a training or presentation or anything that group is putting on. There's just such a depth of knowledge. Even the frequently asked questions section of the website is actually like really good, and I return to it for their definition of restorative justice. Because a lot of the spaces that I'm in, folks who are, you know, I'm talking to are other lawyers, they might think of restorative justice as a diversion program. And for me, really understanding the philosophy behind restorative justice has been really beneficial in trying to kind of effectuate more of that paradigm shift and really encourage people to think about harm and how we address harm in a different way. And it's just been beneficial to my life. You know, I mean, that's one of the beautiful things about working in restorative justice, is it is life-giving work. The philosophies and principles behind it are things that are really fundamentally about how we relate to one another and how we develop healthy and long-lasting relationships and community. And it's something that, you know, I'm hoping to get more into this, but it's something that I hope to you know, use to enrich kind of the community at my work and within my life. And I know that it's just had a profound effect on me in terms of the way that I see the world and the way that I relate to other people in a way that I'm really grateful for.
Oh, thank you, Tristan. That was so sweet. And I definitely, yeah, what I put in the chat is also very true. So please, everyone, check it out. Tristan is incredible. I can't say that enough. I do really quickly, I know we're out of time, but yeah, I would love to lift up for this question a woman by the name of Sandra Rodriguez. She does the work with me. She has been in the work as a community organizer for restorative justice and also as a practitioner, a facilitator. But, you know, something that I do just want to flag, even though that was such a beautiful note to end on what Tristan said, but what I am seeing is there have been a lot of people in the fight to abolish certain systems, and some of those systems are using restorative justice as their lifeline. So like efforts to, like in California, for example, probation is now a restorative justice office. Like it almost is, you know, this way in which the systems, you know, have lost so much legitimacy, and they're grabbing at restorative justice as like a lifeline for their own legitimacy. And so Sandra Rodriguez speaks really beautifully about power, about just a long view of this field, of this movement, and things that we, as we go into this field, really should be attentive to, especially because we are going to be given the microphone with our JD. We are going to work in those very systems. And there is a way that I am seeing RJ being used to really legitimize them in problematic ways. And so I would definitely, and she is particularly incredible on how, like, we have to be community organizers as well as like RJ. You know, the RJ and community organizing there's not separation, they're symbiotic. They have to kind of exist in tandem. And so yeah, how do we build power? How do we organize? And how do we ensure that this movement isn't used to you know, prop up systems that we know do not provide any healing for us or each other. So or Hannah.
Yeah, I know we're ending. I just want, if I could share one thing on the mentor question. I try as often as I can to bring in the voices of the women that I work with from inside the women's prison, and they teach me so much every day, like about yeah, what does justice mean? And so I have a quote that I would like to offer. This is from Lila, and she said, "I feel good about having people who listen and acknowledge the work we do. You all see us as individuals, not numbers or a paycheck. In the end, we need each other. We learn and grow by asking questions and figuring out how life can be better for all of society, which includes offenders. Justice is not locking someone up forever for an action that occurred. Justice is looking for solutions to societal problems, helping people realize they have potential and have meaning, from the victims to the perpetrators, and then having meaningful conversations that bring healing."
Yeah, I love that. That's such a beautiful note to end on. So thank you so much for sharing that. And thank you to all three of our panelists for being so generous with your time and experience and perspectives. It has been so wonderful to have you. That is the end of our symposium. And so just a few closing thoughts that I will share. We have a closing question in the chat if you are willing to share your thoughts. Just what is something that you are taking away from today? If you want to pop your answer in the chat. We do have a contact shared document that I will share in the chat as well if you would like to stay in touch with other folks from today. So I'm going to add that in the chat as well that everyone can access. We will be posting recordings of the webinar from today onto the National Center's website. So you can go ahead and find those on our website, as well as share with colleagues or other people who might be interested. And just want to thank everyone again. Thank you to our panelists for sharing their time and work and wisdom, and for all of you for participating. Thank you.